All right, I think we are all up and running. I'll let you know when we need to be on the record. We're going to have a bunch of things that don't need to be on the record. So I'll do my best to say, now let's go on the record, or are you ready? Something like that. You're welcome. So we've got a plea and arraignment calendar with an add-on and an inquiry calendar for this morning. And Ms. Wood, I think, is in Judge Ingram's courtroom for some reason. But I have asked Judge Ingram to be prompt with her so we get her back. Not Ms. Rios, that you can't handle everything, but there are a bunch of cases that are hers, I think, the calendar. So
I have notes.
Yep, we both have their notes. Yep. So we'll navigate it. I'm not saying let's not start. I just am noting that I have encouraged my colleague to get her here ASAP. All right, let's start with the plea and arraignment calendar. Position 1 is Angelo Williams. He's also position 2. Not here. I got an email. Because it came late last night and was forwarded to me this morning that Mr. Brown is withdrawing as Mr. Williams's lawyer. So if he shows up, we'll need to see if he can afford an attorney or what the situation is. But that may end up being a bench warrant. Put a little question mark there. Position 3 is Willie Jones. Oh, you did a waiver for him, but he needs to be here.
He was, when I texted him, he was parking.
Okay. We'll come back to Willie Jones. Cardius or Cartius Wise.
That should be conflict.
Okay. Oh, everyone was excused. Look at that. All right. So Ms. Dilligard, there's been a waiver done, and I don't know Sarah Stewart, cousin named Sarah Stewart, but it's not the same one. And I guess I'll get a scheduling order in place and it'll move along.
Okay.
So waive and schedule 8. Oh yeah, look at this. This case has a lot of defendants. Mr. Brown, good morning. I got your motions to withdraw. We just need to see if Angelo Williams shows up. I mean, it's not going to affect you at all. But when he gets here, we can just have a conversation, assuming he gets here.
He's in Jackson.
Oh, he's in Jackson. Well, thank you for clearing that up. You are withdrawing. Were you appointed or semi-retained?
Yeah, retained.
Okay, so you're withdrawing. He's in GDC custody. Is it your best guess that he will need appointed counsel?
Possibly. I can't say for certain because he did retain me.
Right.
So,
but now he's locked up, so maybe income is lower.
Yes.
Okay. So we'll need to reset to see how we can connect with him virtually, and then we'll see if he's planning on hiring someone. Do you know why he is at Jackson?
Yes. He had a probation revocation matter in February, and he was revoked 9 months.
Okay. Did you assist him in that? That's how you know about
I
it?
presented him for that.
Got it.
This
Okay.
was part of the reason for the withdrawal.
Okay, all right, whatever happened. Then if that's the only business you have here this morning, you're good to go because he's not gonna be showing up because he can't. But if you've got other cases,
I do not, but if the court needs his GDC number, I have that.
that'd be great. Oh, we got it.
Oh, you have it?
One of the team members has it. So we will find, well, he's at Jackson, but we'll figure out a way to connect with him and just on an inquiry calendar, figure out if he's planning on hiring someone or if he needs appointed counsel. These look like cases that are work outable, but who knows? We'll need to get him a lawyer. Thank you, Mr. Brown, as always, for being diligent.
Have a good day.
You too. Thank you. And you're copying Ms. Nelson? Great. No bench warrant. All right, well, we'll give Willie Jones another call. Willie Jones? We'll come back to that. So Mr. Wise already has done a waiver. We'll do a scheduling order. Co-defendant is Jairus Talbot.
That is a conflict also. I submitted the conflict yesterday. Because he's one of the.
Yes, he's one of them. So you flagged it for your office, whatever it is, to manage and get someone assigned.
Yes.
All right, but
Judge, he's gonna be coming in. He's walking in. He called me this morning.
okay, we'll hold for him and needs conflict attorney. Okay, give me 1 second on this. All right, we're gonna get Ms. Wood back temporarily. Tyson Lemons, he should be in custody. Okay. And you are?
I'm Kenneth Glenn. I entered my appearance actually on yesterday.
Okay,
And I represented Mr. Lemon on some related matters before that I'm gonna need to have an opportunity to speak with both of them and
so we may have met, I know Mr. Lemons pretty well. He was in drug court for a million months. And I know he had something in another county and you may have come to court once. Well, it's good to see you again, Mr. Glenn. All right, so you are, there was a lawyer named in this, but I guess you just filed an entry and that would replace Ms. Gerber. So we've got Mr. Glenn and Mr. Lemons is here. Do you want to talk with him first?
I would, it'd be good.
Okay.
Yes, and I'd like to have an opportunity to speak with
You bet. So what I'll do is finish calling the calendar. We'll take a little break. You'll be able to go back and speak with Mr. Lemons. Ms. Dilligard, who's the one in the middle at the table there, is the prosecutor who will be handling both of his cases, one of which is the new charges with the co-defendants. It's the CSX alleged burglary. And then he's got a revocation on the case that I'm assuming was what he was in drug court on.
Yes,
So we'll work through all that and we'll have a conversation.
thank you.
Sure. Kendrick Varner. What do we have here? Ms. Wood. Okay, she's tried reaching him, hasn't heard back. It's an old arrest, but if he doesn't make it, I guess we'll do a bench warrant. Jordan Stevenson Warner. All right, Ms. Wood says she's tried to reach him, but he may have a warrant, so he may choose not to come in. See how that goes. Elijah Oliver. All right, we're 0 for 3. I feel unpopular. Linton Greenway. Hey, thank you for being here, Mr. Greenway. Appreciate that. Your case is old also, but you got word. Let's see if I don't have any notes on you.
He is minor. I have not had the chance to talk to him, so we could talk to him and, get his information.
Okay, but he'll be your case?
Yes.
Okay, Mr. Greenway, Ms. Rios, is likely gonna be your lawyer. She'll talk to you about whether you're gonna hire one or you need one appointed, and if appointed, it'll be Ms. Rios. And then we'll have a quick conversation after that. Today is plea and arraignment, so probably not resolving your case today, but we'll at least figure out a way to move forward, okay? So if you'll sit tight, when we get through calling the calendar, Ms. Rios can talk with you. Travius Stringer. Okay. Hello, Mr. Stringer. I'm Judge McBurney. Ms. Wood is the lawyer who will likely represent you. She is coming from another courtroom right now. She's normally in this courtroom, but got pulled into another one. When she gets here, she needs to talk to you to see if you qualify for appointed counsel or if you're planning to hire one. So she'll be here in just a minute. And when we finish calling the calendar, she'll talk with you. Please don't leave until you and I talk again, okay? All right. Vincent Wells. Hey, Mr. Wells. I'm doing all right. How are you doing? Ms. Wood is your lawyer, this invisible person. She'll be very visible in just a minute. And she's going to talk with you briefly, and then the three of us will talk and you'll be on your way. Okay. Miawana Walker. It sounds like you've done a waiver and she was excused.
Yes.
Okay. How would you say her first name?
Yeah.
It's a complicated first name. All right. Well, I'll get a scheduling order taken care of, and that will keep moving. And finally, Nathan Murph. He was excused. Ms. Kim, but she wasn't taking cases anymore. Did a waiver. So we'll do a scheduling order. Waive and schedule. All right, the add-on calendar, Rashad Broderick. Oh, it's Broderick Leak. This is funny. I apologize. The calendar, one calendar lists the names, last name, and then first name. And then this other format, it just lists your name, Broderick Rashad Leak. And so I was flipping it around. I know who you are, Mr. Leak. We need Ms. Wood to get here because we're going to be talking about your bond. So if you'll take a seat. How about Tremaine Denson? Hey, Mr. Denson, we're going to be talking about your bond as well. You have managed to get yet another lawyer involved with your cases, and he can't be here, which makes our conversation complicated, but we'll come back to you, okay? And then Xavier Mosley, hopefully is here. We're going to have a Ferretta conversation, but that can wait. And then we had an inquiry calendar. Alan Wade got, Ms. Rios withdrew her motion for bond. I'm sorry if you didn't get notice. I think Ms.
Yes, I did.
You did, okay. Okay, you're welcome to stay, but I think that was your one case. I want to let you know that Ms. Rios withdrew that. So hopefully he wasn't brought over, but if he was, I'll just say, hey, nothing to do today. And that's it. All right, you may. Good seeing you. So back to that inquiry calendar. Positions 1 and 2 are Samuel Jones. That's Ms. Wood. We got to wait for that one. Okay. Damazi Stokes should be in custody, and that's Ms. Cabrera. We're holding on her. Talked about Alan Wade. So that gets us to Danelle Pierce. He should be in custody, or she?
I see it. I see it.
Oh, well, he's got a bench warrant.
Okay.
Okay. Well, that's Ms. Cabrera, so we gotta wait anyway. Don't know where he is. How about Nazareth Davis? Excellent. All right. we need to talk about your ankle monitor, but we need Ms. Wood for that. And she is hopefully on her way. I don't know what is happening.
She's gonna be coming down soon.
Soon, Judge Ingram said she could go. Was she like going somewhere else?
No,
Okay.
I'm sure we have some.
It's one floor away. All right, so that's where we are. Why don't we take, Mr. Abate, I didn't see, oh, you're here for Mr. Mosley. Got it. All right.
If it's okay with your honor, I'm gonna go down to Judge Whitaker for my hearing in 1C, and then I'll be right back.
Great. Yes, Mosley will probably be the last thing we do this morning, partly because we don't have Ms. Wood and it's the longest. If we can get folks out of here by putting that last for this morning. So get on back when you can.
Thank you, sir.
All right. Did anyone not hear their name called? They thought they had court today and they didn't hear their name called. No. Okay. Then Ms. Rios, why don't you chat with Mr. Stringer? And if there was anyone else you needed to chat with, and hopefully Ms. Wood will make it from one floor away to talk with her clients.
Good morning. Morning.
Morning.
I have one, because the David Nazareth Davis is my case.
Mhm.
But I have one position on Judge Edwards, and so is it okay if I peek over there real quick?
Sure. Why don't you do that? Because we'll need Ms. Wood to talk about Mr. Davis's case anyway.
Okay, I'll be right back.
Okay, sounds good. Thank you. Mr. Talbot. Hey, I'm Judge McBurney. Your case has a bunch of co-defendants. And so are you planning on hiring a lawyer or do you need one appointed? Or you don't even know what your case is about? Okay, well, let me give you a quick update and then we're probably going to need to reset this for you either to hire a lawyer or if you need one appointed, we have to get one appointed. Well, I think your lawyer was a public defender. And the public defender, I think, already represents a co-defendant in here. But this case involves an allegation that you and Mr. Wise and Mr. Lemons and a Willie Jones, you should not talk about the case. But I'm just telling you what the allegation is that the four of you broke into 3 cargo containers at the CSX shipping yard off of Boulevard, not too far from here. That's the allegation. Today isn't the day to say that's crazy, you got the wrong guy, or, oh, I want to admit to it. I'm just letting you know what you're charged with. You've been indicted for it. And you're going to have to start coming to court for it like you did today. You can represent yourself. That's usually a bad idea. You can hire a lawyer. If you qualify to have one appointed, we can make that happen. It won't happen today, but we will get what we call a conflict lawyer to represent you, someone who is independent of the lawyers representing the other defendants. So I'm happy to get you a copy of your indictment if you want to see that and take it with you. You need to let me know if you plan on hiring a lawyer or if you need us to appoint one. Okay. Let me look up your situation. Hello, Ms. Wood.
Good morning, Judge.
I'm told we can have you here until your client is available in Judge Ingram's courtroom.
Correct.
I don't mean to make you shuttle back and forth, but there were lots of folks who were anxious to meet you. And if you were just cooling your jets there, then we're happy to have you here.
Yes.
All right, Mr. Talbot, here you are. So you were arrested in July of 23. Surely you remember, I'm looking at your booking photo. You remember that's what this is about. Whatever you were arrested for in July of 23, that's what this case is about. So I can tell you that.
They didn't tell me anything.
Okay, but so you may have a fascinating defense. I'm trying to connect the dots for you. for some reason you were arrested in July of 23, that's what this case is. The warrant says you entered the CSX Railroad property without permission, and you, along with others, blah, 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 blah. But I'm gonna give you a copy of the indictment. You'll get your lawyer, and we'll take it from there. Yeah, your lawyer at the time, and this was a long time ago, that's the same day of arrest and whatnot, was a gentleman by the name of Justin Showalter. And he handles cases at the preliminary phase for the public defender's office. But he cannot, well, one, he's not assigned to my courtroom, but his office cannot continue to represent you because the public defender's office is connected with now one of your alleged co-defendants in this case, and that's Mr. Jones, Willie Jones. One of the people you say you don't know, doesn't matter whether you know him or not, he's a co-defendant, so you got to get your own lawyer. Not meaning you have to hire one, but we need to get you a lawyer who's independent of that office, okay? So let me print this, 3 pages. And the last thing I want to confirm with you, how'd you know to be here today?
Funny thing, something called Simply Billsman, texted my mom at 4:43 and said, you have a court appearance today. Then I called the clerk. She said that y'all removed me off the calendar for today. Yes, that's exactly what she told me. So
Okay.
I called your office.
Okay, thank you for coming down. I have an address of Wesley Providence Parkway, old address. There is an address change form that Deputy Gordon's going to give you. If you'd fill that out, I'll make sure it goes into the system because we'll be mailing you notice when you need to come back so you and your lawyer can meet and we can start talking about your case. So if you'll fill that out, I'm going to give you a copy of the indictment and then we'll mail you a date. Let's take a minute to move up. And if you put down a good phone number, we can get that in the system as well. Cell or home, whatever works for you. Ms. Wood, on our inquiry calendar, we have Samuel Jones. It sounds like we're resolving that today? Okay. And Deputy Gordon, you've got Samuel Jones here? All right. So that's ready to go. And then Stokes is Ms. Cabrera. So we could talk about Mr. Davis, if you had a chance to talk with him, because we're having issues with his ankle monitor. I don't know who represents the state on Mr. Davis's case. Is that you, Ms. Clark?
Yes.
Okay. Well, why don't we knock that one out after? Give. All right, did he go away? Okay. Mr. Davis, why don't you come on up to the podium with Ms. Wood, please? Not yet. I'll let you know. So Mr. Talbot, you've got a copy of the indictment now. We'll have your address and phone number. We'll let you know when you need to come back to court. And we'll have a lawyer here who will be representing you at that time.
Okay.
Any other questions other than what's this all about?
I think, but I'm not talking, I'm not gonna talk to the lawyer, I don't wanna,
Yeah, Mr. Showalter's not here. He doesn't work in this courtroom. He handles these first appearances and
I never really talked to Showalter either, so.
no, I that's usually not how it works. I hear you. All right, Mr. Davis, let me get your case up on the screen here. I have been getting emails from the ankle monitor company saying you are not complying with whatever the limitations are. You have an ankle monitor, yes?
Yes, sir.
Okay. And we need to figure out, one, do you really still need to have an ankle monitor on? It's been on forever. And then two, if so, what is the issue with either where you're moving around or what the deal is? So here's your bond order. Judge Locke in November of 23, so a long time ago, set a bond. You're paying for the ankle monitor.
Sir.
Holy smokes. Okay.
Yes, sir.
And you had, today's your plea and arraignment day. So we're doing two things here. We're taking care of arraignment and we're talking about the ankle monitor. So Ms. Wood,
Yes, Judge.
first, is Mr. Davis waiving arraignment?
Yes, Judge, and I will file a waiver at some point today.
Okay, we'll take care of that. Mr. Davis, I've got an address of Jumpers Trail in Fairburn.
Yes, sir.
That's a good address?
Yes, sir.
Excellent. That's what's in the system. That's what we'll use. Your bond order from way back when, which hasn't been modified, says you have a 24-hour curfew except for medical, work, school, religion, and legal meetings with your attorney. And you're supposed to stay away from Union City, so the entire city,
Yes.
and KIPP Atlanta Collegiate.
Yes.
So those are the requirements of the bond, and they haven't been modified. We're going to talk today about whether we should modify them. And if so, I can do that. Ms. Wood, have you had a chance to talk with Mr. Davis about what these constraints are doing and how he might want to have them changed?
Yes, Judge, and
Thank you.
we would be asking the court to remove the ankle monitor. It looks like he's been out on bond without any issues since 2023. I also think as long as he complies with the stay away, I think the 24-hour curfew, I don't feel like there's a need for that at this point since he's had no issues since 2023.
All right. Ms. Clark, what are your thoughts about Mr. Davis's bond? Well, I'll ask some specific questions and then you flesh it out however you want to. Does your file indicate that there have been any concerns from the alleged victim's family about Mr. Davis being nearby, having contact, anything like that?
No, Your Honor.
Okay, so it sounds like compliance has been good in that respect. Okay. Mr. Davis, are you working?
No, sir.
Okay. Pardon me?
Go ahead. Go ahead, sir.
So the kinds of emails I'm getting from the ankle monitoring company show this red line about where your ankle monitor was, and it's going from Fairburn up into Atlanta. And the statement on the email is, it doesn't appear that Mr. Davis had a reason consistent with his curfew to be wherever he went. It's not that you were going to a forbidden location. It was, if it's a 24-hour curfew and you haven't presented documentation that, well, I'm working and my job is in Midtown, okay, that would show you going from Fairburn to Midtown. So that's why they flagged it.
So I referee high school and college basketball as well. So
you are working?
well, not necessarily. I mean, some of the weekends, yes.
Okay.
Yes.
All right.
So with that, if I go tell them I'm going to Canton On my way home, I stop by my brother's house and I go home. That's the red flag. And I let them know that I'm going to my family member's house, or I'm going to dinner or what have you. Everything I move, every all move around, you know where I'm going.
Okay. All right. So you do have work-related reasons to get out of the house,
Yes.
and that's the high school basketball.
Yes.
Okay. So high school basketball season is
It's over, but now I still do EYBL, which is it's a
Youth basketball league.
yes, youth basketball league. And
You
sometimes-
coach or ref?
A ref.
Okay. And that takes you outside of Fairburn?
Takes me outside of Fairburn, takes me outside of town. I've been to last summer. I worked in Salt Lake City, Vegas,
Okay.
and Reno.
Okay.
And I let them know.
Great.
And I let
And then
them
I
know.
say you didn't let them know. It may be once or twice the left hand and right hand didn't
Yes.
connect. I'm just
Okay.
exploring what's going on. So do you do other things that you don't call work besides refereeing basketball? That's it?
I was coaching high school football, but I'm not even coaching that now.
Okay. Was that at Kip Collegiate?
No, I was working there, but I was
Okay.
coaching at Alexander High School.
Okay. Got it.
Judge McBurney, I have a correction, I'm sorry. So there is a note, our advocate did speak with the victim's mother regarding the ankle monitor. She did say she's not would not be comfortable with the monitor being
Oh, come
removed
on, man.
because she saw the defendant in public, which leads her to believe that he is, still in the area.
And this note is from when?
This is from, 5/1.
Meaning 5 days ago?
Yes.
Okay.
See me.
All right.
Okay, I'm sorry.
And did she say if this Publix was in Union City or where the Publix was, or just she was in a grocery store and she's,
In public,
in public?
There was
Oh,
no specification as far as where.
Got it.
but She did see him.
Okay. Got it. Okay. So Mr. Davis, we're going to do this in phases. I'm going to modify your bond and make the ankle monitor paid for by the county. And I'm going to remove the curfew. So you can go wherever you want to go, but we're going to have ankle monitor for a couple more months. And if there are any reports about concerning contact from the household I asked about, then we'll be able to figure out, because we had ankle monitor, where you were and where you weren't. But I'm taking it off of your bankroll and I'm removing the curfew. So you don't need to report where you're going.
Sir.
You're just going to have an ankle monitor on. Is your ankle monitor with A&A or Talatrix?
I think it was Teletrix.
I mean, you're paying money. To whom are you paying money? Talatrix?
Sir.
Okay. So we're going to swap it out and you're going to get an ankle monitor from Second Chance. That's the vendor for the county funded ankle monitors. And I'm going to ask Ms. Wood to remind me in 2 months if your case is still pending and there have been no reports from the DA's office about concerns about where you were. And there's really no place you can't be other than you cannot go in Union City, and that'll be programmed into the ankle monitor. And then you're staying away from that KIPP Atlanta Collegiate. And then obviously it would be if you, for whatever reason, notice you're coming near the family of the alleged victim, you need to move away from them. This isn't the time for you to say it didn't happen.
Yes, sir.
I am reducing your bond conditions.
Okay. Yes,
Thank
sir.
you, Judge.
Ms. Clark, other ways you think a bond ought to be modified? I heard you loud and clear. I'm not ignoring that. And I'm keeping an ankle monitor on, just tweaking some of the other conditions. Are there things you'd like to see that you think would address the family's concerns?
Not at this time, Your Honor.
Okay.
I think, I have no problem. I'll defer to the court.
Okay. So to repeat, Mr. Davis, I'm going to modify the bond, strike the curfew, and turn it into a county-funded ankle monitor. And then you and Ms. Wood just need to remind me if it's been 2 months and there are no issues, we'll get that ankle monitor off as well. All the other conditions are in place, so you don't go anywhere near Reagan Barber, stay out of Union City and stay away from that school. And I'm not saying you've been there, you keep shaking your head. I'm not accusing you of anything. I'm just reminding you, because the quickest way for your bond to turn into a jail cell would be to
Yes, sir.
have your ankle monitor in downtown Union City.
I understand,
So
sir.
I know you understand it, so just cope with it for
Yes, sir.
another couple months. My goal is to have this case move forward. These allegations are very old. That's not healthy for you. That's not healthy for the little girl and her family.
Yes, sir.
And so closure is needed, whatever closure looks like, dismissal, 100 years of prison, or somewhere in between.
Yes, sir.
And my goal is to get us there.
Yes, sir.
I'll enter a scheduling order, which will trigger a requirement for Ms. Clark to get discovery to Ms. Wood.
Yes, sir.
Ms. Wood, please let me know if you don't get discovery by the deadline, and we will make things move along. And I think that is it. Anything else? We got a good address for Mr. Davis. Anything else? You'll get that waiver when you get a chance. Anything else from the defense?
No, Your Honor, thank you.
Ms. Clark, anything else from the state?
No, Your Honor, not at this time.
Okay, well, thank you. Mr. Davis, you are free to go.
Yes, sir. Thank you.
All right, did Willie Jones make it? Not yet.
Not yet, Your Honor. I did want to discuss, Mr. Linton. Number 11, Mr. Linton Greenway. He does not qualify for services at this time.
Mr. Greenway, where's Mr. Greenway? Right there. Hey, Mr. Greenway, I know you don't feel like Bill Gates, but you are going to need to figure out if you can afford a lawyer. And what I'm going to do is reset this for about 30 days. I don't have a date certain. I'm going to confirm your address in a minute, meaning that we've got the right one in the system. You'll get notice to be back here in about a month. And we'll have another conversation. You'll either show up with a lawyer that you managed to retain, or we'll have a discussion about, is that feasible? How's that working? And we'll figure something out. This is an old case. It's a new indictment, but your booking number is from, we have a bunch of cases from 23 here, and now they've been indicted. And I want to make sure we can move this along for your sake, as well as for whoever the alleged victim is in this case. So you're all right with that? You don't really have a choice. Okay. So it sounds like if Ms. Rios is saying we're not able to, that says you are employed and you're making a little bit. And so you're going to need to engage with a criminal defense attorney. You might want to talk with 2 or 3 to do some rate shopping to see what you can find out. Let me look up your case. All right, so I've got an address on Stokes Wood Avenue, 951. Excellent. That's where the next letter will go, saying you need to come back to court, and you need to do your best to come back to court with a lawyer. And then that lawyer and you and I and Ms. Dilligard, who's the prosecutor on your case, will have a conversation about how to move it forward. We'll actually do your arraignment. Your lawyer will probably waive your arraignment, but a lawyer needs to say that for you, that, hey, Mr. Greenway is waiving his arraignment. Your bond order, which was from long ago, May 1 of 2023, it's now officially 2 years old, said that the alleged victim, a Tony Williams, does not fear you and is fine with bond. And so you got the bond that you got. And the only conditions were to stay away from Tony Williams and this one address on Moreland. Those are still the conditions. If for whatever reason that's become problematic because that address on Moreland is where your uncle lives or something, then when you do get that lawyer, we can talk about modifying the bond. It seems like complying with the bond has not been all that burdensome for you. Is it a fair statement? Okay. All right. So to recap, you'll get something in the mail with a date a month-ish out to be back here with an attorney. And we'll try to move your case forward then. Any other questions? You know what these charges are about?
To be honest, y'all, this is the first time I actually heard people's names.
Okay, well, let me tell you what the indictment says, and they're just allegations. The allegation was that in April of 23, you assaulted Tony Williams with a handgun by pointing it at him, not shooting it, but pointing it at him. So something happened in late April of 23, allegedly between you and a Tony Williams. And I don't want your theory of like, wait, no, he's the one with the gun. You and your lawyer will talk about that. But just to plant the seed in your mind, like, why are they making me come to court? That's what the indictment says. So that means a police officer got in front of a grand jury saying, here's the information I have. However, that officer got it. The grand jury true-billed it. And now you've got these formal charges that you and a lawyer are going to need to work through. Okay? Any other questions?
No, sir.
All right, so I will see you in June sometime. You'll get that date in the mail. Hopefully you'll have a lawyer with you, and we'll move the case along. All right, you're good to go. Any other announcements? Ms. Rios, Ms. Wood?
Judge.
Judge, I've joined, I'm sorry.
That's all right. Ms. Cabrera, how are you?
I'm wonderful. I joined your calendar. I have Mr. Pierce on your calendar. He should be on virtually, however.
Okay, you do. You have a couple of clients. You also have a Damazi Stokes, I think.
No. So, no. So what's going to happen? And I think Miss Charles, I don't know if Miss Charles is in the courtroom, but I know, yes, she is. She's in the courtroom. I see her.
She is, and I got an email
message
too
to
about
Miss Nelson, right? So he has new cases that are going to Judge Farmer. There's a question about where this probation violation is going to be handled, but the probation violations are not supposed to be coming through us under Mr. Luemba's agreement. He doesn't do post-conviction matters, but he's going to, I guess, speak with him. I spoke with him last night, and he said he'll address that issue because we shouldn't have any post-conviction cases.
Meaning you shouldn't have them. Stokes, I guess, it was your client and pled or resolved his case with me.
I don't know where Stokes came from. I just got an email that said do an entry of appearance for him. And then after doing so, realized that that's not an active case. That's a case that was in probation status. And so I asked Mr. Luemba about that then, and he said we weren't supposed to be getting any post-conviction cases.
Got it.
Then further in that process, I learned that he has other cases that were pre-indictment, but it looks like they've been indicted to Judge Farmer.
Got it. Yeah, so it's peculiar that you were given this. Ms. Wood took the plea, and so she would very naturally handle the revocation, but it makes sense for the revocation to go to Judge Farmer, who they're now indicted, so they're active cases with him. So I will tell Mr. Stokes, you don't need to stay on for that. We'll take care of Mr. Pierce in just a second. But I'll tell Mr. Stokes that it sounds like Mr. Luemba is agreeing to handle it sort of in connection with the two open cases.
If he's handling he probably will. I mean, because there's probably going to end up being some sort of global resolution if he has the new cases that are assigned to Judge Farmer.
Got it. Okay. Then you're off this one, and I'll let Mr. Stokes know that. And then you have Mr. Pierce, who has a bench warrant. So I'm confused as to why he's not in court. But Mr. Pierce, we're going to...
That's my fault. I told
put you on the screen.
Yeah, that's my fault. I sent him the link to join virtually. So that's all my fault. I did speak with the state yesterday. and she doesn't have any objections necessarily to setting aside the bench warrant, but she's definitely going to leave it in the discretion of the court.
Okay, well, let's talk about it. Hey, Mr. Pierce, can you hear us?
Yes, sir.
All right, how you doing today?
I'm doing fine, and you?
I'm all right. Are you at home?
Yes, sir.
Okay. Your case was transferred to me in September of last year. It had been in non-complex for a long time. And I guess they figured out, based on your criminal history, it should be bounced up into Superior Court. We had a court date just before Halloween and you did not make it. So I signed a bench warrant, and I'm going to let Ms. Cabrera explain how it came to be that you knew you had a warrant and you're here, and what I should do. Ms. Cabrera?
Yes, Judge. So again, him appearing virtually is completely my fault. I didn't even think about that. I was appearing virtually. I sent him the link for him to appear virtually. But so it appears as though the clerk's office has a Sable Crossing address for him, as well as a Lower Creek Drive address for him.
I'm only seeing the Sable Crossing in Suwannee.
Okay, from what I understand, he received notices to both addresses at some point or another. Prior to the October date with Your Honor, he received a notice, I guess, while he was still in non-complex. He received notice for court at Lower Creek Drive, which is the correct address. I think the address that was used when his case was transferred to you, however, was Sable Crossing, which is the wrong address. So the clerk's office has access to both addresses, but they sent his notices to the incorrect address when the case came to you.
Got it.
But what's strange is that I think he may have gone to court in non-complex September. I mean, was it September, Mr. Pierce?
Yes,
In
ma'am. It was
September.
September.
Okay, so in September, they sent him notice to the correct address, and then the address was changed when it came to you for October.
Okay, I'm looking at the notices that were sent out for my plea and arraignment, and you are exactly right, and we'll clear this up hopefully, but now that he's got you, you'll be able to help out as well. But the notice that was sent out for the plea and arraignment that Mr. Pierce did not make went to that Sable Crossing in Suwannee. And you're saying that's an old bad address?
Correct.
Okay. So we'll need to do a change of address form so that we have that address you've mentioned that somehow non-complex was able to use. We are not able to use it because it's not in the system. But we'll get it changed. And let me see.
Mr. Pierce, did you already, well, we'll have to do it again. We'll have to do the address change again. Okay.
Yeah, we'll do that again. So there's already been a waiver of arraignment. That happened 18 months ago back in non-complex. So what we'll do here is, did you didn't have the case, you wouldn't have had the case in non-complex, Ms. Cabrera? Okay. So I guess what we'll do is just do a scheduling order, and poor Ms. Dilligard will have to do discovery again for the state because it'll be the first time going to you, and we'll move the case along that way.
Okay.
So if you'll do a change of address and get that to Ms. Nelson, I'll set aside the bench warrant.
Okay.
Because it doesn't sound like Mr. Pierce was willfully missing court, although I'll hear from Ms. Dilligard first. And then we'll get a scheduling order in place.
Okay, perfect, Judge. And I have his new address, so I can do that later.
All right. Ms. Dilligard, your thoughts about Mr. Pierce's situation?
And I don't have any objections to setting aside the bench warrant, seeing this that he didn't get good notice and time, so we have no objection.
Okay. Then we'll do that. Mr. Pierce, you have any questions?
No, Your Honor. I would like to just thank you for understanding and handling the situation.
No problem. So what's going to happen next for you is that your lawyer, Ms. Cabrera, will get discovery, and then she'll want to meet with you to talk about the discovery. That's going to show whether this is a messy case for you or an easy case for you. And then she'll start giving you advice on how maybe to resolve the case with a plea, or maybe there should be a suppression hearing because the police stopped you in a way they shouldn't have stopped you. But she'll advise you on that. I will see you next, either because there is a motions hearing or because you all have worked it out, and we'll be talking about what that's going to look like. Okay?
Yes, Your Honor.
All right. It does look like Mr. Pierce was in jail for a long time in connection with these charges until he was able to make bond or for some other reason. But I'm sure we'll factor that all in. All right. If there is nothing else, and that's your only case, Ms. Cabrera, you're good to go. Mr. Pierce, you are certainly free to go now.
All right,
Thank you,
Your Honor.
Judge. I will be popping into Douglas County and then Gwinnett, but if something weird happens, let me know.
All right. We know how to track you down.
All right. Thank you, Judge.
All right.
Thank
Yes.
you so much.
Can we bring Stokes just to the door while I remember? What? Oh, arrived? Willie Jones. Which one is Willie Jones? Hey, Mr. Jones. Hey. Ms. Rios, you're going to talk with Mr. Jones?
I brought a waiver, so he,
I still need to talk. Do you want to talk with him before? We will still have a conversation.
I don't
Okay, all right. Let me deal with Mr. Stokes and then we'll do Mr. Jones. No one seems to know anything about their cases today. Mr. Jones, do you know why you're here? Okay, well, that's refreshing. And Mr. Glenn, are you, I don't mean to keep you sitting around all day either. Are you ready to, do you need to talk with Mr. Lemons?
I need to talk to Mr. Lemons.
Okay.
Also.
You're still doing your thing?
Yes.
Okay, just let me know when you're done with that thing.
Thank you.
Hey, Mr. Stokes.
Good morning.
Hey, you can stay right there. No, you don't have to go anywhere. I'm just giving you an update. Mr. Stokes, I thought we were going to handle your probation revocation today. You have picked up new charges and I signed a probation warrant in connection with that. But it turns out that your new charges have been indicted. You have 2 new cases and they are both going to Judge Farmer. And the lawyer who is representing you in those 2 cases is going to handle this revocation in connection with those new cases. So Judge Farmer will handle the revocation, and Mr. Luemba, your lawyer who's got your new charges, will manage this revocation in connection with that. Well, let me tell you, you have Ms. Charles left. Oh, you're still here. It's 2 new cases, isn't it? I don't have that email anymore.
25 FC 001239.
And?
25 FC 002322.
Sorry.
I'm gonna tell you. So 25 SC 002322. One of them, Mr. Stokes, you are charged with aggravated assault, discharge of a firearm near a public highway or they dismissed that part. So possession of a firearm during commission of a crime and aggravated assault. Your arrest date for that was February of last year. And your other case is, well, that's what it says here. And the other one is aggravated assault and simple battery. And that one, it lists the arrest date of February of this year. And that one got dismissed. And so you're probably thinking, wait, why am I here? But it got dismissed because a police officer didn't show up for a preliminary hearing. And then the very next day, the district attorney's office presented some evidence to a grand jury, and you and someone named Swift and Artravius Beatty and Jameer Abdal Aquil all got indicted for stabbings. Oh, this must have happened in the jail. I don't know. Anyway, you guys are charged with stabbing a guy named Keontae Hurd. And we don't need to go back and forth on this. I'm just letting you know, you got 2 new indictments. They're with Judge Farmer. Those indictments are the reason we were going to be talking about a revocation. And it makes sense to have 1 judge, 1 defendant, 1 lawyer manage all that. So your revocation is going to Judge Farmer. All right? See you around.
Thank you.
Thank you, Ms. Charles. You should have left faster. Okay. Let's work with Willie Jones. Mr. Jones. How'd you know you had court today? Okay. I'm looking up your situation. Here you are. We've got an address on Hubbard Street. Is that still a good address? No, sir. All right. Well, I'm gonna have Deputy Gordon give you a change of address for, actually, Ms. Rios, have you already done it?
The change of that.
Oh, you did on the 29th. Let's see what this says. Your lawyer's been working hard on your behalf. I got a Fremont Street. That's a good address? All right. So your notices in the future will be going to Fremont Street. Hopefully, I don't know why that's not in the system already, but it should reflect that. So the mail goes there. And your bond, which you got way long ago, says that you are supposed to stay away from the CSX rail yard on Boulevard. That's really the main condition. You've been staying away from there? Good, keep doing that. You'll get notice when you need to come back to court. Your lawyer is going to get discovery from the prosecutor, and then she'll want to talk with you about it and review it with you. And if it makes sense to file any motions, she'll do that. Otherwise, I'll see you on what's called your final plea date, which is one of the last days to work your case out, where you can withdraw your plea if you don't like what happens. Any questions for me? Okay. We'll stay in touch with your lawyer. If you move or you change your phone number or something, let her know. She needs to be able to find you. All right. Do you need Mr. Jones to stick around? Ms. Dilligard, anything from the state as to Mr. Jones?
No, Judge.
All right. Thank you for being here, Mr. Jones. Women's. Did Mr. Varner or Warner ever make it? Nope, we tried. All right, and I have your notes, Ms. Wood, that you tried to reach some of these folks, but didn't work out. Whoops. How about Jordan Daniel Stevenson Warner? Same situation. All right. And Elijah Oliver. Oh. Okay. Mr. Stringer, did he requalify?
Rios is speaking to him on
Right now, they're having a conversation. Excellent. And Mr. Wells is here. Hey, Mr. Wells. Good morning. So, Ms. Wood has filed a waiver of arraignment on your behalf. All that means is she's entered a plea of not guilty for you, which is how 99.9% of these cases start out with me. I'm looking your case up right now just to see if there's anything we need to work through. I've got an address for you of Arno Court.
Yes, sir.
That's a good address. Excellent. And your bond says that you have to stay away from an address on Abner Place. You sure can. That's what my look was like. So have you been doing that? Not so much. Oh, Norris Anderson is deceased? Okay, well, proof of that is probably gonna lead to a prompt resolution of your case. You'd be surprised how hard it is to prove that someone's dead. I'm not doubting you. But they gotta get a death certificate and this and that. But if your lawyer is able to get a death certificate for, you didn't kill him. He was saying, you got charged with doing something to him. How do you know he's dead? Oh, I'm sorry. How long ago did he pass away? Okay. Well, this is what happens when there's a situation back in 2023 and it gets indicted in 2025. I'm sorry for your family's loss. We need to track down a death certificate. Did he pass away in the Atlanta area?
South Atlanta Road.
Okay, well, I didn't need the specifics, but like it's a Georgia death, so we should be able to get that. Then let's all work on that, state and defense. Mr. Wells, I may not see you again in connection with this case, and that's okay. If for some reason, actually your cousin's just in hiding and he's not dead, then I will see you again and we'll be working through the case. But if he has passed, then that sort of ends the prosecution. Yes, ma'am. Oh, I thought you raised your hand. You're just making sure your hair, all right, it looks great. Okay, we will move forward. I'll still do a scheduling order, and then we'll just hit the brakes if a death certificate is tracked down. Any questions for me, Mr. Wells? All right, if you get a notice in the mail, come back here. You should come back. You should call Ms. Wood saying, wait, I thought, my cousin's dead. But there may be some strange reason why you need to come back. So don't assume the case is closed until Ms. Wood reaches out to you saying, hey, the state dismissed. We got the death certificate for Mr. Anderson. All right? All right.
Thank you, Judge.
Nice meeting you. All right, that covers that calendar. All right, should we take a quick break so you can talk to a few people?
Yes, Judge.
All right, I'll come back in about 5 minutes. We have Mr. Leak we need to talk about. Mr. Mosley, we're going to do at the very end. I think there are a few revocation things we could do. So why don't you chat with folks and I will be back.
Counsel wants to approach on this matter.
Okay, I gotta go make a quick phone call. So when I come back from that phone call, we'll start, three of us can talk about Mr. Lemons.
Okay, thank you.
All right?
Well, I gotta go to the stairs. Okay, out. Okay. Oh, yeah, there's a country going all the way. Now, okay, yeah, all right, so.
I'm sorry. It was a lot easier. It's not so that thing. Go me.
Confusion is for this new saying was. He was going to say, yeah, that's what he's telling. And yeah. But he's in custody. Yes.
What do you need from him? Besides his money.
Yeah, okay, I'll basically one.
I already explained everything that she wants. Perfect. Thank you.
I've done this. I've done explosion. I'm all probably. I'm working cool, so they said.
No, because these are mine.
He's in agreement.
Do you have a video?
Yes.
Yes.
Are you working with you? Yes.
Okay, yes. We're gonna have to wait a minute for her. Okay. Okay. Yes, we're doing. Okay. Are you there? No, this is good.
It's just, I'm sending this here. Okay.
Appreciate it. You're welcome. Yeah. Are you gonna have our changeable release? Not today, but in the future. 101, I'm not too many. How many people? This is one that's 70, that's on the page.
On the clean arraignment calendar? Yeah, he had it private, but it's private with.
Yeah, he was here.
I think that would be Lacey, because I think I looked at it, the older case was her number. Yeah, it should be Lacey's. Where is he?
So who was the attorney? Said it was a private attorney?
It wasn't private, but he was here, I think she said it was Lacey.
Oh, it was Jones. Oh, okay, Brown, so Jim Brown.
Yes.
Oh, okay. So then it's yours?
It should be Lacey's because the older case ends in the lower number. But we're switching one case, so she has room to give me a case. So I don't know if she's picking this one or another case, but we're switching a case. But I don't know what she's going to choose to give me. I'm not sure if it's this or another one. But are we just resetting him to, was he brought over?
Oh, I didn't know he said.
We're just resetting him.
Well, we'll probably do it by Zoom the next time.
Okay.
It probably won't be till July.
Okay.
Yeah, just. Some of us, we can close the room. Yes.
On Garner? Yes.
And you go some order.
And when did Oliver come?
No, oh, he's on the top.
Oh, yeah. Staying here.
Who represents on 12?
Stringer, it's gonna be mine.
Okay. Okay.
Oh, is that? It's not. This one is.
Oh, it's not actual. Okay, what's my actual?
Yeah.
I was talking it's only.
Yeah. It's definitely up there, because I turned this off. Or any of them, like,
Still, okay, so.
You don't have a record.
I might compute it as well. This, it's a super, yeah, probation. They just text me over, come back down. I'm like, oh my God, I can't have stuff to be right now.
Okay, this is probation revocation.
Yeah, so it's the violations or it's just. We had our like day of release date. Back in February, yeah, and I got the release date, like, it was a mess, so then went through like 5 minutes. Then we find the managers. See what it was.
You said the main thing.
Regulating to everything. Yeah.
Ms. Wood, you need to go back to Judge Ingram.
Yes, Judge. I was gonna leave a couple of things in Ms. Rios, and then I feel like maybe I should probably handle the Project Leak matter.
Yes, you should be here for Mr. Leak. We'll do that when you return.
Okay.
All right?
Judge McBurney, I need to go to Judge Gilbert. Back to Judge Gilbert. But Leak.
Give me one oh, Leak is your case? Perfect. Yeah, why don't you guys both go take care of these other judges? Steal you away.
All right.
I will. Yeah, Joe was triggered.
Mr. Glenn, do we need to speak privately or you just want to let me know what's going on? Okay. Should we go to the jury room?
Yes, that's right.
Okay.
Yes.
Right. It would definitely be with the prosecutor.
Can I go back, can I go back and talk to, Samuel, what's his face? Yeah. We're gonna handle him for Tracy.
Stokes, she's going back.
Samuel Jones.
Family.
Yeah, Samuel or something.
Two Jones. Oh, that's the lesson. Yeah.
You had to talk to us. I know she wanted to. Yeah, I'm going to. So. I haven't been. So, yeah, we're still visiting this one. Let's see, we're looking at this stand for additional year, okay? Yeah. Husband is gonna stay on the judge. And I was like, what? Do you think it's so fun? Because I initially my recommendation is. What have you accomplished? I'm not hard. My last ones were actually rather. Well, I had to understand. Did he run? No, he actually, like, I was starting from New York State. And in addition to special probation, plus he had paid his restitution for his probation. True. I didn't need that. You're going to jail for years. That's being a good thing is like, no. And that's the thing you have to do. Very expensive. That means it's take a lot. I'm just sure that's that's making up with 18 months. We would have to go and pick it down and then she found out this is revocation. 18 months. But he just finished before that. He's a very nice man and he cried for about 4 months. Gordon, don't have to say that. I was doing 18 before. That's 16 months. Wait, no, time out. That's 18 months. 18 months. And before, that's 14 months. That's the longest every year. He was too scared. He needs to 8 months. 8 months. Talk for that. If she's good with it, I'm saying, but like I said, my initial recommendation was for 2 years. What happened to you? You were prepared for it. He is a pretense on my like, I don't want them until my case. Wait the case. But when it comes to me, you have to. But see, legacy cases, I told her, I said, I have this thing about I keep giving her bad news. Yeah, I was like, one last time I'm taking away the case, because you do that with my stuff. And I was like, yeah, one day, one day, we're gonna have a case where you actually won't care for me. We ain't got there yet. But how much time was all guys for? Well, we're gonna agree with that. I have a. Everything. I haven't talked to him. Okay, but it's been. Mr. Linden. Curious as to what that conversation about. Yeah, he's in behind. He is, because, yeah. He's not my lawyer, he probably. He saw the. I mean, he finished. He completed. No, he completed. He is gonna be on, he says, yeah, I'm recommending my brother is 3 years. I told you when that's when he did vacation, because I have better reputation. No, I told you what happened with him. He, in Dutch County, he had this whole thing. We have bronze. Oh, lunch. No. It's like a game.
Man, see the court on the water. I'm gonna go back.
You're gonna check on,
That's Stokes.
it's us or it's theirs?
Stokes.
Really? And we're ready for lemons after you sort out the hammering. Hey there.
Hey, I mean,
I'm well. You can go to the podium. We're just going to talk briefly about scheduling. I had a little conference with Mr. Glenn and Ms. Dilligard. Ms. Dilligard is the prosecutor handling your new charges, which are kind of old, but it's a new indictment. It's stuff from 2023, and as well as the revocation, because I signed a warrant to revoke your probation on your old case because of these new charges. And Mr. Glenn is looking to have a global resolution where we talk about revocation and maybe resolving the new charges, but he needs to get the discovery first, which is a bunch of video footage from the CSX rail yard here in Fulton, some still photos, et cetera. So the state will get that to Mr. Glenn in the next day or so he can start reviewing discovery. Mr. Glenn, were there other things you wanted to cover today?
Briefly, Your Honor.
Sure.
With regards to, and I understand as well that is the case, new case we're here for, scheduled for arraignment today. We're in a position to waive a formal arraignment on this, and so that we can facilitate discovery. Anticipate, we're all working towards a prompt date with regards to the scheduling the revocation. And in that regard, I would request, for request, to allow Mr. Lemon to be released up until and appear at the time that we have scheduled for the probation revocation hearing. He's promptly appeared in court on all occasions that I'm aware of when he's been required to do so, and that he doesn't pose a flight risk or anything like that. And in that regard, and because we're talking about a relatively small window and a good bit of evidence to review for the revocation hearing, I think it's going to be substantially dispositive of the probation hearing. I would request that he be granted probation bond, and, with the idea that we're really talking about, weeks, a month as opposed to some more extended period of time. And so, Lemon I can assure you, I think the indicated that he would be present for that and appear for that. And certainly help greatly aid my efforts in representing him as well.
Okay. Ms. Dilligard, do you have, what is your perspective on some form of release pending the revocation hearing?
They would object to his release at this time. However, as soon as the waiver is filed, I can get discovery over to counsel as soon as possible, so that he has ample time and enough time to review that discovery as soon as possible, so that we can move this matter along.
All right. Mr. Glenn, my thought is, well, Mr. Lemons, you're the one who's in custody, but I'm responding to Mr. Glenn's sort of request / mapping out the schedule here. I'm going to keep things as they are for now. So that's keep the probation warrant in effect that holds Mr. Lemons. You'll get this discovery today or tomorrow, Mr. Glenn. And my request to you is that you dive into it, at least initially, right away. That's not me saying, please master it all right away. But if you take a look at it and say, gosh, I'm not going to be ready to do a revocation hearing in 6 months. That's a very different landscape than, Judge, it'll take some work, but I'm up for it. And I could be ready for a revocation hearing in 2 weeks or 3 weeks. That'll help me better assess what to do here. And I don't say that to encourage you to say it'll take 6 months, because it shouldn't take 6 months. Everyone should be focused on sorting out the revocation part soon. But as you've mentioned, both here in court and when you and Ms. Dilligard and I met in the jury room, one really resolves the other. If we have a revocation hearing and I find that the state met its burden to prove by preponderance that Mr. Lemons was mixed up in some way in entering these cargo containers at the CSX lot, you might as well resolve the charges also. And you may also look at the evidence and say, after you consult with your client, we don't really even need to contest it. And really what we should focus on is what is a reasonable resolution of both the new charges and the revocation. And I'm confident that you'll give Mr. Lemons good counsel on that front. You should, if you feel like you need to review some of the evidence with your client and he remains in custody, let Ms. Nelson, that's my litigation manager, know if you need an order that would get you and a laptop into the jail if you want to review things with Mr. Lemons. But I will also be open to hearing from you if you say it's 65 hours of video and that's not going to work sitting at the jail with someone. And that might be a reason to say, all right, let's get this revocation hearing date set. And maybe a few days before that, Mr. Lemons becomes available outside of custody. But my goal is to figure out how we get everyone back in court for the revocation hearing the soonest. Okay?
Yes.
So, Mr. Lemons, that was sort of an indirect way of saying I'm not going to release you right now. You're going to stay on that probation warrant. Mr. Glenn will have a chance to look at discovery first on his own and then talk with you about it a bit. And we'll figure out how quickly we can get the revocation hearing set. I'm ready to do it, but the state would need to bring witnesses in. And equally important, Mr. Glenn needs a chance to look at it so he knows what he's defending against. If there's video footage of you holding up a sign saying, this is Mr. Lemons doing his thing at CSX, that's bad evidence for you. But if it is grainy footage that shows 3 guys walking around in a CSX yard, then query why you even got named in this one. And they just grabbed 3 guys and maybe it's not the right 3 guys. I don't know what the evidence shows, but Mr. Glenn, of course, needs a chance to look at it. Okay? Any questions about any of that? No? Okay. Mr. Glenn, I appreciate you being here this morning. If you fill out that waiver and get that to Deputy Gordon, I'll make sure it gets filed. You may have already filled it out. I'll make sure that gets filed. That'll get the ball rolling, and then just keep us posted once you've had a chance to look at that discovery.
All right, thank you.
Okay.
I will do that.
Can we go to number 12, the previous speaker?
Yep. Mr. Stringer, yes, you were gonna talk to him on behalf of Ms. Wood to see if he's still qualified.
Yes, he does qualify, and, Ms. Wood will give a waiver in, and she may have exchanged contact information.
All right, let me look your case up, Mr. Stringer, and we'll get you out of here. So I've got an address of Lyle Place. Is that where you stay? Old address.
I gave you,
Oh, we got yours. Oh, yeah, Marietta Street, an apartment on Marietta Street. Okay, that's where your mail will go. And then let's look at your bond. You're supposed to stay away from some guy named Samuel Andrews. Do you know who that is? Yes? Okay, you staying away from him? Okay, good. That's the main condition. Keep doing that while you're on bond. Ms. Wood, who had to go back to another courtroom, will get the discovery in your case, whatever the police reports are, this and that, and she'll meet with you on that. And you guys will start talking about what does the outcome look like in this case based on what's in the discovery. If she files any motions on your behalf, that's when you'll be back in court next. If there's a motion to suppress or whatever it is she files. If she doesn't have any motions, then we'll get you in here to talk about resolving the case. Any questions? Okay. Well, you remain on bond. You'll get notice at that Marietta Street address when you next need to come to court. If something changes about phone, email, address, let Ms. Wood know. Stay in contact with her, okay? All right. Ms. Dilligard, anything in connection with Mr. Stringer's case?
Okay.
Ms. Rios, anything else?
No, you're right.
All right, Mr. Stringer, thanks for being here. You are free to go.
When you're ready, I'll be handling Samuel Jones from this list.
Samuel Jones. Oh, the revocation?
Yes.
Great. Should we do that?
Yes.
Ms. Dilligard, you ready for that?
Yes.
Okay.
It's just, yeah. It was just technical, it's fine.
Hello, Mr. Jones.
How you doing, sir?
I'm all right. Slide back that way, please. All right, let's get on the record. These are positions 1 and 2 on our inquiry calendar, State versus Samuel Jones. Mr. Jones is here for probation revocation. It's a case from 2010 and 2011, both burglary. Ms. Simpson, how much time remains in Mr. Jones's cases?
On the 10 SC case, it's 2 years, 8 months, 15 days. And the 11 SC case is 2 years, 7 months, 16 days.
All right, thank you. So, Mr. Jones, you've got a little more than 2.5 years left on probation in both those cases. You've got long sentences in those cases.
Yes, sir.
I don't have any of the probation warrants. The notes on the calendar say that this case had been reset from February so that Ms. Rios, your team could look for a program or housing for Mr. Jones. And so we must have made a record back then. Did Mr. Jones already admit to what the allegations were?
Yes, I believe this is, if he stipulated.
Okay, and does anyone know what the allegations were?
Initially, the warrants were for technicals for, he failed to complete the MADRC as well as, he has a rearage of restitution and probation fees. And the research of my doing this calendar, it came across on his criminal background that he picked up a possession of firearms and charged into the
Okay, and there was never any probation, anything in connection with that? Okay, is Mr. Jones on notice for that? Was there a petition ever done?
That is looking for, it is, he refused to sign.
Okay, he was presented with a petition by one of your colleagues.
Yes, and
How recently was that?
this is January 7th.
Of this year, okay. All right, so all that predates our original revocation hearing, which was February of this year. Okay. I'm just trying to make sure, Ms. Rios, we're covering the full landscape. So the basis for revocation would be technical, didn't complete MADRC, technical, behind on restitution and probation fees, and then was at least arrested for in DeKalb County for a possession of a firearm by a convicted felon, but back in 2023. All right. And what is your recommendation?
He's been in for 5 months. I'm asking for
7 months.
7.
I got a lot of them out there with them in the cab.
Okay, so 7 months total because he spent 2 months in DeKalb County before he was brought here. I'm asking to revoke 7 months and continue him on probation. He has been accepted to the PAD program. Ms. Wood is working out the transportation situation with that, but he can go there, and he has a drug problem. He's been addicted to crack cocaine for years. He's eager to go to PAD to address his drug problem. He does not have any children. He's 53 years old and lived in Stone Mountain most of his life. He was looking for Fresh Express, and he believes that he can, with the services of PAD and helping him with his addiction, have full-time employment and then be able to pay his fees. His issue has been homelessness and like job instability, and with the service and PADs that he can be able to meet the condition of probation. I don't believe him serving more time is going to get the victims their money any quicker. And so with him addressing his issues and working, that's why I'm asking for him to only be revoked the time that he's been in. And this was a substantial amount of time. It was 7 months.
All right. I am looking at a couple things here in his case. So Judge Wolf in 23, June of 23, revoked 90 days. Mr. Jones, had been directed to do Sober Living America and left that. And then there were some arrearages. Okay. And then I do have a petition.
He did want me to let you know that he did graduate from Gateway.
Okay. All right. I now see the petition with the refuse to sign part. That's got all those things we mentioned. Let me check one more thing. Okay. Mr. Jones, why do you think PAD is going to work when some of these other programs didn't work?
Well, Gateway, I actually graduated that program, but they had PAD. I spoke with the person at PAD, so they have a therapist there, and we worked on a treatment plan that will probably help me out better because they had the resources. Most of these things were based on my addiction with homeless. I had no place to go, even though I was working. And once I got paid, I just went back to my old habits, addiction. And most of that was not having no housing. Once I came out of the system, basically, it was just, you're homeless, you don't have no place to stay, you have no foundation. So that's what I related to. It's hard to get an apartment with my record.
Is there a reason, Ms. Rios, that your team didn't look into accountability courts?
There probably was one, but I'm not sure what that, I'm not sure. You're right.
Okay. All right. Because I know that housing can be a component of that treatment, at least initially. Okay. Ms. Dilligard, what does the state think should happen here?
The state's recommendation is to revoke 2 years and reinstate the balance based off of him being in possession of a firearm, in addition to the technical violations. I have notes that he has been revoked on this case 4 previous times. And so that was taken into account when speaking with probation on a recommendation. And I do have concerns about the PAD because I know we can't make it a condition. And so the concerns of him leaving a previous program doesn't make me feel really confident that he will attend PAD in addition to us not being able to make that a condition. So the recommendation of the state is to revoke 2 years.
Got it. Okay. Ms. Rios, do you know what, if anything, happened with the DeKalb case?
I am not sure, Your Honor.
Do you know, Mr. Jones, have you gone back to DeKalb to resolve that?
No, I came from DeKalb, so they got me. I'm on bond in DeKalb.
You're on bond for that 2023 gun case?
Yes, I'm on what do you call it? Signature bond.
Okay, something like that.
Yeah,
got it. Okay, all right. Well, Mr. Jones, you got one of these sentences. Your cases went through formal court we don't have anymore, the standard track, and the judge there gave you a very, very long period of probation. There was some time to serve and then a bunch of probation. Given the number of revocations that Ms. Dilligard mentioned that I'm seeing in the system here, I don't think returning you to probation makes a ton of sense. I think you would benefit from some additional treatment, and I hear you that it's awfully hard to stay on track no matter how much you want to if you don't have economic support. And so if you are working but are stuck back in the streets, it's just so easy to slide back into the familiar habits where you're in a comfortable place and the people around you are using and you got some money and you use. And that doesn't make you a bad person. It means that it's harder to push back against your addiction. And I wish there was a magic solution for that, but there's not. Age helps. I think eventually you're going to get sick and tired of cycling in and out and in and out. What I'm going to do, Mr. Jones, is in light of you withdrawing on your own from MADRC.
What's MRDC? I don't even know what that is.
So it is, do you want to bring them back out here? No? You sure? All right. It's the Day Reporting Center. So that was, your probation got amended after one of your revocations where a judge said you need to do the day report. It's sort of like drug court, but it's run by probation. And you report to this place, the Day Reporting Center, every day.
Oh, that's the reason why I didn't sign a petition. I did report, and Gateway is another thing that they said on a petition that I did. I completed Gateway. So those are the reason why I didn't sign. The gun charge was the one that was October 3rd, but I reported and I graduated from
Gateway?
Gateway.
Got it. So you were choosing not to sign it, not because you're being difficult. You're saying, right, I didn't do this thing.
And I spoke with Ms. Ross, and my Miss Woods about it, and they was supposed to, which she isn't here today, she was supposed to bring that up on the petition. I did complete that.
Okay.
I graduated.
What about sober living?
Sober living, I left sober living.
Okay.
Right.
You left sober living.
I relapsed on sober living. That's what
Okay.
happened right there.
And I follow you on Gateway. You graduated Gateway. That's actually not in there. No one's saying you didn't do Gateway, but the day reporting center is different. Tell me about that.
I reported the day we sent it, but I was supposed to be going to, they sent me to Gateway, and I was going there in the daytime. I was in Gateway at the time. I was right, the probation place is right next to them.
Yeah.
So I went there every day. Then I came back, and then they said I was waived 6 months for restitution pay. Didn't have to pay. Then I had to pay restitution to the Sprint store, and I said I was in Gateway the whole time.
Okay. All right. I'm concerned about the restitution, meaning people are owed that money, but you're not, I don't think you're hiding money somewhere else so you can get a.
But I did report on the day report, but I was in the program. That's the crazy part about that. It was 2010, I believe, is when I got that case out. When I think I was in front of Judge
Downs.
Yeah, Downs.
Yeah.
Whatever.
Okay.
Yeah.
All right. What I'm going to do, Mr. Jones, is revoke a year of your probation and close out your 2 cases. So you are not going to be on probation when you're done with that. So I will suspend or terminate the balance, whatever the correct box is to check. But the purpose, the intent of my order in light of those new charges you picked up in DeKalb. And to me, that's the most serious of these things. And I'm hearing you finished Gateway, didn't do so well with the sober living, but you relapsed. That's why people leave a program like that. And the MADRC is a little murky to me, but what's not murky is these new charges added to CAB. And we just need probation. That has been a struggle for you. You don't have the support network you need outside, and that keeps you bumping into probation again and again. And so you will have done 12 plus years of the 14 of probation, and it was a rocky road. I don't see the value in saying we're going to squeeze you for 2 more years on that.
Revoke a year. I understand what you mean. Revoke 1 year with the 7 months I got already.
And then I'm terminating the balance.
So I had to do a whole year. That's what I'm saying.
No, I don't do that math.
Yeah.
You'll get what I mean, it's parolable. I don't know.
That's the state time.
Correct. Yeah, and they'll figure that one out. And when you are released, you are not on probation in Fulton County anymore. You will need to deal with your DeKalb charge still, because you said that's out there, but you said you got a bond on that. Do you have business in any other county, or that's it?
I have none in the other counties.
Okay. All right. That's the plan. Thank you.
Your Honor, a just quick question. I just want to make sure I understand, because I know we had that issue before about like the credit for time. So this is just your intention is before.
Right,
Okay.
right. Because the credit for time, it's a dangerous concept in that, because we revoke based off of the remaining balance, which is the balance today is this. We're going to have some judicial and litigation manager training on what happens when people say credit for time served. I don't know under Court of Appeals precedent, we're allowed to say that. I mean, I can say those words, but Superior Courts have been now reversed a few times for saying credit for time served. The Court of Appeals has made it pretty clear that unlike an original sentence, when we're dealing with probation, that's math that GDC handles. Okay, the most it will be is a year. It cannot be more than that. But it's parolable, good behavior, the grid, all that kind of stuff. Okay.
That's what I'm saying. So it's 1 year to serve. That's what you're saying. No 1 straight. That's state time.
Correct.
So that's prison.
It is. That's right. And then you're done. No more probation in either of these cases.
I don't got no choice. You made a ruling on that, though. You know.
I did. I'm just letting you know it's not just, hey, 1 year of prison time. It's then we close out probation on these 2 cases.
All right.
All right. Thank you.
All right.
Ms. Rios, do you have anything else or anything else you're covering for?
Who's left? Let me see.
So we have Mr. Leak, but that's got to be Ms. Wood and Ms. Clark. They're not here. There's Mr. Denson. Are you here to help with Mr. Denson? Ms. Rockwell, or you're just watching?
Oh, no, I was gonna come make sure.
Mr. Hayes showed up?
Worked out okay, I was.
He started crying and he wanted to be able to stay out till his revocation hearing. But he didn't resist. I mean, it was this, there was a lot of boo-hooing and he had 3 people with him and he said, thank you. But I'm not a bad guy. I will show up. Can't I stay out? I said, we worked through this, Mr. Hayes. You know what the deal is. The best thing you can do is go real quietly and peacefully with the debt. And he did. There was no, they need to bring in 6 deputies or anything like that.
And Judge, I did not put in much.
No. It wasn't going to change anything.
I was getting nervous that he might be late.
He was late. He got here about 9:30, but I got your email saying he was running late. So it was all good. And it worked. And so I'm going to tell other judges, this is the sheriff's office was hugely appreciative. Because the olden days, it would be send 4 deputies with this guy to the funeral. And they're standing there and we're taking 4 deputies out of service or 2. And that's not the right use of deputies. So it's on me. And he didn't abuse that trust. And I told him that's going to put you in good stead when we do get to your revocation.
I think his family knew that, so.
They did. They kind of nudged him that way, like, come on. So,
Yeah, you're here. You knew you were turning back in, didn't you?
Yep.
I didn't know you were gonna try to renegotiate the deal with you,
It's all right.
sell you a used car.
Yeah. Mr. Denson, you hired Mr. Smith
Yes,
for both your cases.
yes, he's currently in charge of Cherokee County.
He is. He's a very good communicator. He let me know the situation. So we're gonna reset this for as soon as I can get him in court. You will not get something in the mail. You're gonna get a call from Mr. Smith saying you gotta come to court. What I think I ought to do with your case, I really can't do without a lawyer here on your behalf. So you remain on bond in your 2 cases. And once we can get Mr. Smith in here, he'll reach out to you. He knows how to reach you. He's got phone, email, all that stuff. Okay. When he tells you you need to come into court, you need to come on in, so that he can hear what my concern is and defend you. And then I'll hear from the prosecutor on it and we'll figure out what we're going to do. Okay. Any questions about that? All right. I'm going to figure out when we can pry him out of one of those. You're not going to get a call today, meaning come back today. You're good for today, but we're going to look at his schedule to see when we can get him in here so we can have this hearing that I intended to have today, and then you switch lawyers. So don't switch lawyers again. Stick with Mr. Smith so we can make this happen. All right. See ya.
I can stand in for Xavier Mosley's friend here.
Why don't we start that?
Oh, okay.
Oh, do you want to take a break to get Stokes downstairs? He's good? Okay. Just trying to help.
She's some kind of person.
Sitting down.
What's wrong?
Mosley at podium sitting down.
Podium. I mean, he's mobile.
Yeah.
Yeah. No, this is a one-on-one. And this will be on the record, and this will take a little while. Good morning, Mr. Mosley.
Good morning, sir.
Give me 1 second here. I'm just getting your indictment up on the screen. There it is. And one other thing. Is. All right, let's get on the record. This is 24 SC 05005423. Mr. Mosley, you told me last time we were together that you wanted to represent yourself. Maybe this hybrid representation where Ms. Wood would sit with you at the table, but that you would be your advocate at trial. Am I remembering correctly?
Yes.
And is that still your intent?
Yes.
Okay. You have a right to represent yourself. And I am required by law to honor that right after we have a conversation. During this conversation, it may seem to you that I'm trying to talk you out of representing yourself. And in some ways, that's kind of true because in my experience, and I've been doing this for a while now, defendants who represent themselves, especially ones in custody, and you're going to stay in custody until your trial, they're at a disadvantage when they represent themselves. You're still free to do it, but there are a bunch of things I'm going to cover with you saying, hey, if you had a lawyer, you could do this and this and this. You understand? You're not going to be able to do that if you represent yourself, and you're going to tell me whatever you tell me. But I want you to understand in the end, it's still your decision. I'm going to be nudging you against it, but when we finish the back and forth we're going to have, I'm going to ask you what it is you want to do. And if you persist in wanting to represent yourself, you'll be allowed to do that. You understand that?
Yes.
Okay, great. Let's get started. Mr. Mosley, how old are you?
I'm 36 years old.
Okay, how far did you go in school?
I got my GED while incarcerated.
Okay, what were you incarcerated for?
A list of charges.
What was the most serious one in your mind?
Armed robbery.
Okay, and were you in Department of Corrections when you got the GED, or were you in a local jail?
Yes, I was in Department of Corrections.
Okay, how long were you in overall for that case?
10 years.
Okay. How long ago was it that you got your GED?
It was like 2015, October.
Okay, so about 10 years ago?
Yes.
When did you get out for the armed robbery sentence?
November 17th, 2022.
All right, you remember these dates?
Yes.
All right. So that means you can read?
Yes.
And you can write?
Yes.
Do you have any difficulty understanding written or spoken English?
No.
Have you ever worked before?
Yes.
What kind of work have you done?
I've done cooking. I've been a chef at the Waffle House.
Okay. How long were you a chef at the Waffle House?
Like 2 years.
Which Waffle House?
Peachtree Street. Peachtree.
There are probably like 10 Waffle Houses on Peachtree. Which one?
It was the main one up in Lindbergh, Buckhead area.
Okay. How'd you get that job?
I just filled out an application.
And you got it?
Yes.
Why'd you stop being a chef at Waffle House?
I stopped because I was caught smoking marijuana on the job.
Oh, they don't like that at Waffle House?
They don't like that.
Okay. All right. Have you ever studied the law before?
No.
Have you ever watched a criminal trial before?
Yes, I've seen shows like CSI.
Okay.
Law and Order.
Got it. Lots of people have seen those. You realize that those are actors and a real trial may be kind of different from what you've seen on TV.
Yes, I'm aware of that.
Okay. People aren't as well dressed. They don't speak as smoothly, but it may be a different flow as to what happens in a real criminal trial. You understand that?
Yes.
Okay. Your armed robbery conviction, was that a plea or a trial?
It was a plea.
Have you ever been to trial yourself? Okay. And it sounds like you've not ever sat in a courtroom to watch a trial, but you've seen snippets of a acted out trial through these shows you mentioned.
That's correct.
Okay. Have you ever represented yourself before in any civil or criminal matter?
No.
Have you ever been treated by a mental health professional, psychiatrist, psychologist, or any other type of counselor?
I've been evaluated but not treated for.
Okay. Did that evaluation result in any diagnosis that bipolar or depressive or anything in that category?
Yes, something similar to that.
What were you diagnosed with?
It was like psychosis, high size syndrome, something like that.
Okay. Were you prescribed any medication?
No.
Okay. Have you ever been prescribed medication for any mental health condition?
No.
Why were you evaluated?
Well, yes, I'll take that back.
Okay.
Yes, I have.
For what?
For depression and this happened recently while incarcerated.
While incarcerated here in Fulton County,
Yeah.
or when you were doing your 10 years?
Yes, while incarcerated in Fulton County.
How long have you been in jail here?
8 months.
8 months. And so during that 8 months, that's when you had your evaluation?
Yes.
Okay. And then you were prescribed something?
Yes.
And what is that supposed to help with?
Depression and I think sleep, insomnia, something like that.
Okay. And do you still take that medication?
Yes.
When do you take it? Night or morning?
Both times.
Both times. Did you take it last night?
Yes.
Did you take it this morning?
Yes.
When you take the medication, does it make you woozy or drowsy or confused?
The late night pills do.
Because they make you sleep, because that's what they're supposed to do.
Right.
Okay, but the ones you take in the morning, do they in any way make it hard for you to understand what's going on around you?
No.
Okay. Tell me why you think you would do a better job than a lawyer in handling your murder trial.
I don't kind of think I'll do a better job, but since my financial status is low and I can't afford a real attorney, and the attorney that was issued to me, I feel that her caseload is extensive and she don't have enough time to really dedicate to my case, that I would be a better representative for myself.
Okay, I follow that. I got a couple comments on that. First, the public defenders are real lawyers. They went to the same kind of law schools. They passed the very same bar exam. And in fact, they probably have more practical experience trying criminal cases and defending people in high stakes cases like this than most anyone you'd hire, unless you're a gazillionaire. And then you might be able to hire the man of steel and we'd see what would happen with that. But short of that, you should know that the lawyer who was appointed to represent you is very capable and has tried all sorts of murders and things like that, sometimes with okay results for her client. But no defense attorney is a magician. I don't know anything about the facts of your case, so I'm making this up. But if your case involves surveillance footage and is real clear, you've got some distinctive tattoos, that you're on the camera and you've got an axe and you're chopping this guy's head off, it doesn't matter who your lawyer is. They're going to have a lot of hard work to do. And so you should think through that as you think about what the evidence is in your case, about whether you think that it would work out better, you representing yourself versus Ms. Wood. So point one is she's a real lawyer. Point two is she does have a lot of cases. So do the prosecutors. But as they approach trial time, all other business is set aside, and the focus of your lawyer as your trial approaches is your trial. And so while it may seem like over the last 8 months, dang, I have not seen Ms. Wood so often. I would like to see her more often. Doesn't she know I'm charged with murder? I want to see her every week. And you may not be that demanding, but there are guys out at the jail like, I haven't seen my lawyer in a week. She doesn't care. She's not working hard for me. The reality is, in your case, over the last month, there really wasn't a whole lot to do on it because the trial is still a little ways off. But as we get closer to that trial date, then you will see, wait, now there's Ms. Wood and she's doing this and she's doing that. In the same way that if you represent yourself, you're going to be doing a whole lot more work the night before trial starts than a month before trial starts. I just want to make sure you understand both those things. I understand what you're saying, and I'm not pushing back on that. I just want the record to be clear that it's a real lawyer. She's a real lawyer. And yes, she's busy, but she'll be very focused on your situation when that time arrives. You understand both those things?
Yes, I do understand that.
Okay. But understanding that, you still believe that it's to your benefit to represent yourself, maybe by having Ms. Wood still there at the table to help translate legal terms and whatnot, but that you would be the advocate for you.
She might, I'm not saying she won't be a better representative, but it's kind of what you explained, that I feel like since I haven't seen her these past 8 months, like I think I should have,
Yep.
that I probably feel like it, but my feelings might be misguided.
I'm not saying your feelings are misguided. I'm not being critical. I'm understanding that because you're sitting there day in and day out and feeling how invested is this person. But the reality is, I know because she's been trying cases in here. There'd be a whole week at a time when she's not thinking about you because she's got a guy sitting right there on trial, rape, and she's focused on that. So I'm not defending or advocating. I'm just wanting to make sure that you are seeing and feeling the whole picture, because it's very natural to be in your lane, which is the murder is a pretty serious charge. And where's my lawyer? And the answer is she is busy, but she'll be busy with your case when we reach it on a trial calendar. But it sounds like you understand that, and you think that your time commitment to the case will be greater between now and then. And so your preference is to be lead counsel, and Ms. Wood would sort of be your standby.
Yes.
Is that correct, or are you now thinking about it differently?
That's kind of where my thinking was headed, but.
Okay.
Yeah.
Well, let's talk a little more and see where your thinking goes. Are you familiar with what you're charged with in the indictment?
Yes, I'm familiar with it.
Okay, we're going to get real specific. In your indictment, you are charged with 1 count of murder, 3 counts of felony murder, aggravated assault, and then some firearms charges. It's just 1 gun, but you've been charged in different ways about possessing that firearm because of your criminal history. The state can charge it in different ways. You know what murder is all about. You know what that charge means, that you're charged with killing someone.
Yes, I do.
Do you know what the penalty is for murder if you're found? The penalty for murder, if you're found guilty of murder, is life on behalf of the state, a notice that triggers a different outcome. Because of your armed robbery conviction, I would be, if you're found guilty of murder, out parole. Life with the possibility of parole goes off the table. Doesn't matter what I think about it. That's the only option because of that armed robbery conviction you have. If you were found not guilty of the murder, but still guilty of any one of those felony murders, it's still life without parole. You understand that?
Yes, I do understand.
Aggravated assault, which is as it's charged in your case, the crime of shooting the victim in the case, that's 1 to 20. Sentence you 1 to 20. Now that would merge into the murder count if you're found guilty of murder, so you wouldn't get a sentence for that. And then there are all these gun charges, some of which might merge into others, but some of them involve consecutive time. It's kind of silly to talk about consecutive time when you get life without parole because there really aren't numbers after that. But if you were found guilty of everything in the indictment, you would be sentenced to life without parole plus additional time in prison. Do you understand that?
Yes, I do understand.
That's pretty high stakes. Of course, if you're found not guilty, you're done. No sentence. Do you have any questions about the charges in the indictment and the penalties that attach to them?
No question about them.
Okay. Are you a U.S. citizen?
Yes.
Where were you born?
Atlanta, Georgia.
Grady baby?
No, South Fulton.
South Fulton, okay. Do you understand, Mr. Mosley, that if I decide that you are knowingly and intelligently deciding to represent yourself, and I say, all right, have at it, and you start the trial as your own lawyer, You don't get to halfway through switch and say, whew, this is hard work. I quit. And then Ms. Wood takes over. If the setup is you are the lawyer and she is your advisor, so that you can ask her, what does hearsay mean, or huddle up with her, you don't get to switch seats partway through the trial and you take the back seat and she's your lawyer. Whoever starts, when we have the jury in here and say, all right, we're going, that person stays as the lawyer, the representative for Xavier Mosley. Understand that?
Yes.
Okay.
I got a question.
Yes, sir.
What if in between this time and the time where I have court, my family all of a sudden come up with the finance to provide me with a lawyer? Will I be able to switch to that attorney then?
So a couple things. One, between now and the start of the trial, you could always say, you know what? I spent some more time with Ms. Wood and I want her to be the lawyer on my case. So you always have that. Number two, more specific to your question, if your family wins the lottery or they dig up a box from the backyard and there's $10,000 in it or more, and they hire a lawyer, that person can represent you, but I'm not going to delay the trial for that person. If that person swoops in, I'm making it up, but if the trial starts next Monday and that person on Friday says, I'm Mr. Mosley's lawyer, that person needs to also say, and I am ready to go on Monday. So that makes it a little harder to find the lawyer, because many lawyers will say, hey, if the price is right, I'll represent Mr. Mosley, but I'll need a few weeks to get ready. I can't just come in and take this cold file and come up with a good defense for it. He wasn't there, it was self-defense, you got the wrong guy, or whatever the defense might be in this case. So yes, your family could bring someone in, but that person would need to come into court ready to roll. Does that make sense?
Yes, it makes sense.
Okay. You should interrupt any other time you have questions, all right? It's important that you ask questions that you've got. Do you understand that if you choose to represent yourself, you are not entitled to any special treatment from me or from the prosecutor? I'll be nice and respectful, but I'm not going to say, oh, you know what, you don't know what hearsay means, so I'll just let hearsay come in. I don't treat you any differently than I would the lawyer who represents you. Do you understand that?
Yes.
Do you understand that you'll be required to follow all the same rules of procedure and evidence that the lawyers have to follow in criminal trials?
Yes.
And that not knowing those rules might make it difficult for you to get a piece of evidence in. You understand that?
Yeah, I understand it.
Well, you might have, I don't know why you'd have it, but you might have a picture that you want to get into evidence. And if you don't know the way you ask questions to what we call lay a foundation for a photograph, then you might not be able to get that photograph into evidence in your trial. Do you understand that?
Yes.
Do you understand that if you choose to represent yourself, you may miss important potential defenses because you're not as familiar with criminal law as a lawyer would be?
Yes.
Do you understand that every time you fail to make an objection, you might have seen that on TV where a lawyer stands up, objection, irrelevant, or whatever the objection is. If you don't know what the rules are, and so you're failing to make an objection, then that evidence that I might keep out, if you made an objection, is going to come in, and the jury will hear it or see it. Do you understand that?
Yes, I understand.
I will not be making objections on your behalf. You understand that?
Yes.
Do you understand that if you choose to represent yourself, what you say to the jury during your opening statement and your closing argument, that's when the lawyers or you stand in front of the jury and say, this is what this case is about. That's not evidence. That's just you telling them what you think the case is going to be about. You understand that?
Yes.
Do you understand that the only way for you to get what you say into evidence would be for you to decide to testify?
Yes.
And then if you choose to testify, you'll be able to tell the jury your version of events under oath, but then you will be subject to cross-examination from the prosecutor. Understand that?
Yes, I understand.
And you don't get to skip those questions because they're hard questions or awkward questions or incriminating questions. You understand that?
Yes.
All right. Do you understand that I will not require the district attorney's office to bring in a new or inexperienced lawyer to handle this murder prosecution just because you're representing yourself?
Right, I understand.
Okay. And while I'll expect the prosecutor to treat you respectfully, I'm not going to expect the prosecutor to go easy or not try to really prove his case just because you don't necessarily know the rules of evidence or the rules of procedure. You understand that?
Yes.
Okay. Do you understand that you will not be given any extra time to prepare for trial if you choose to represent yourself?
Yes, I understand that.
All right. Do you understand that if you're found guilty, you will not be able to argue on appeal? Well, of course I was found guilty. I represented myself. We need to do this all over again where a lawyer represents me. That's not an argument that any appellate court will accept, that you did a bad job representing yourself. Do you understand that? It may be true that you did a bad job, but that's a risk you take if you choose to represent yourself. Do you understand that?
Yes, I understand.
All right. Do you understand that your ability to investigate this case and research it in terms of getting online and look for the law, things like that, that's going to be pretty limited by you because you're stuck in the county jail. You understand that?
Right, yes.
Okay. Do you understand that you have the right to have a lawyer represent you for every stage of the trial if you choose to have a lawyer represent you?
Yes.
Do you understand that that lawyer would, instead of you, pick the jury and figure out which jurors might make good jurors and which jurors might be bad jurors?
Yes.
You understand that that lawyer would also make an opening statement for you, telling the jury what this case is not about and why you should be found not guilty?
Yes, I understand.
Do you understand that this lawyer would have subpoena power? And if there were witnesses that you and the lawyer thought would be helpful to your case, that lawyer could issue a subpoena to compel that witness to come to court to testify on your behalf?
Yes.
You understand that that lawyer would be in a position to make objections on your behalf, so that if the state's doing something that's inconsistent with the rules of evidence, your lawyer could stand up and say, objection, hearsay, objection, whatever the objection is.
Yes.
Do you understand that the lawyer could make motions on your behalf? And if the lawyer felt that there should be a mistrial because something particularly bad happened during the trial, not meaning the evidence wasn't helpful, but there was some misstep during the trial, that lawyer could make a motion for mistrial on your behalf.
Yes, I understand.
Okay. And finally, the lawyer would be able to make a closing argument on your behalf. After all the evidence is in, that lawyer could get up and say, here's why you need to find Mr. Mosley not guilty. Because the evidence was insufficient, this witness was a liar, the state didn't prove this, whatever those arguments would be. A lawyer could do that for you if you had a lawyer.
Right.
Right. And finally, that lawyer would recommend to me what jury charges, the law that I give the jury, what jury charges I should include in the instructions that I give the jury. A lawyer would help with that. Do you understand that?
Yes.
You understand, if you represent yourself, all these things that the lawyer could do on your behalf, the lawyer will not be doing on your behalf because you don't have a trained professional representing you. You understand that?
Yes.
Okay. Got it. Mr. Mosley, has anyone threatened you in order to get you to waive your right to a lawyer?
No.
Has anyone promised you anything in exchange for you giving up your right to have a lawyer represent you?
No, they haven't.
All right. Mr. Mosley, do you waive your right to have a lawyer represent you?
No.
You're not waiving your right?
No, I think I might be good and better off with Miss Lacey Woods than myself, represent myself.
I think you're right. You still could choose to hire a different lawyer between now and the start of your trial. And Ms. Wood will always be consulting with you before trial and, of course, during trial. And so you'll have that consultant sitting with you, but you'll have the trained, experienced professional doing all those things for you, ranging from opening statement to cross-examining the state's witnesses, to arguing motions, to filing jury charges, et cetera. And if you have concerns between now and trial that you aren't getting enough contact, write a letter. And certainly during trial, you can bring that up outside the presence of the jury. But I think you will find that Ms. Wood will advocate to the best of her ability on your behalf. Again, I don't know the evidence in the case. You may have a particularly tough case if there are a lot of eyewitnesses, or, and I'm making all this up, your DNA is all over the scene, that kind of thing. There are times when an amazing lawyer, someone like Ms. Wood, she can't make gold out of garbage. But you may have a great case, and you'll have a good lawyer who will be pursuing the defenses that are available to you. All right?
Yes.
You have any other questions about anything?
No, I don't.
Okay. Your case is coming up for trial soon. So I expect Ms. Wood will be out to see you soon to talk more about the case. I appreciate you having this conversation with me. I told you that I was going to be leaning in the direction of you not representing yourself, but that's only because I don't think that that is ultimately in your best interest to try to fly solo. It's complicated flying in a courtroom. And having watched CSI and those other things give you a flavor for how it could be interesting, but not a flavor for how much work it is and how many technical details are involved. I'm hearing you say that you are withdrawing your request to represent yourself. You're going to team up with Ms. Wood, and you should know Ms. Wood will have a trial partner for the trial as well. You may not meet that lawyer until just before trial. There's actually going to be 2 lawyers working on your behalf when trial starts, because even the best of lawyers like Ms. Wood need and value having a trial partner once you're getting into it. So she'll be the subject matter expert and will know the ins and outs of your case, but there'll be another lawyer sitting with you and Ms. Wood who will get to know you and will learn enough about the case, might even handle some of the state's witnesses. So it'll be a team of 3, you, Ms. Wood, and whoever that person is. All right?
I understand.
Anything else you want to talk about today?
I wanted to know, can some of my motions be put into place where I can get those granted? Because I would like a full package of my discovery and the things I asked for in some of my motions that I filed.
Okay, so Ms. Wood is going to be back here soon. She's in another courtroom right now, and I'll talk with her about discovery. These days, a lot of discovery is digital. It's videos and things like that, and we can't get that to you. You can't have a thumb drive legally or a DVD at the county jail. But what we do need to do is make time for Ms. Wood to get out there with a laptop so you can watch that with her. But the paper discovery, you're certainly entitled to that. And I'll ask Ms. Wood when she can get that to you so you at least can be reading police reports and things like that. But the digital discovery is the kind of thing you'd review with Ms. Wood or an investigator from her office when one of them comes out to visit you at the jail. Okay?
All right.
So I'll talk with her about that when she comes back down here.
Let's do that.
All right. Anything else?
No.
Mr. Abate, anything from the state in connection with Mr. Mosley's case?
Nothing, other than I served on Ms. Wood's, late yesterday afternoon. The GBI report relates to firearms, came back, in which the firearm that Mr. Mosley had when he was arrested hiding in the attic matched the ballistics evidence from the projectiles pulled from the body of the victim and 2 shell casings that were left behind after he shot the victim.
Okay. So Mr. Mosley, this is one of those this just in pieces of evidence. The state wasn't sitting on it, but the state crime lab has been doing some work on evidence that was allegedly collected in your case. And you heard what Mr. Abate said. I don't need to repeat it, but there's now been an expert from the GBI who's concluded that a weapon that supposedly was on you when you got arrested is forensically linked to bullets in the deceased and some shell casings. Ms. Wood she got that report yesterday, so she'll talk with you about that. I suspect she's going to tell you that's not a good piece of evidence for the defense, but she will be thinking through how to explain that in a way that would make sense to the jurors in connection with what these charges are. But a helpful aspect of what Mr. Abate just shared with you is you can see how this discovery is dynamic. Mr. Abate just got that last week. He just got it to Ms. Wood, so she's not been sitting on it. She didn't have it. She couldn't share that with you. We knew it was out there. When we last had you over here, I asked, this is when you said, I'm not pleading to life without parole or life, whatever the offer was, which I understand. Mr. Abate had mentioned that there was that one remaining piece of getting the ballistics evidence from the GBI. Sounds like they've completed their work just in the nick of time, and we'll take it from there. All right?
Yeah.
So I'll talk with Ms. Wood when she comes back in here about seeing you and getting paper discovery to you, and then I'll leave it to the two of you, Wood and Mosley, to do the rest. All right?
All right.
Thanks for talking with me.
Thank you, Your Honor.
Oh, Deb, we have court at 1, right?
We do.
I can print out paper discovery to help save Ms. Wood some time and bring it back for him to
Just no, keep him right there for 1 second.
take back to jail. I confirmed with Deputy Gordon that he will likely still be here at 1 o'clock.
Can we keep him? He doesn't necessarily need to stay. I'll defer to you. Mr. Mosley, my goal is to get you, you'll need a bigger envelope than that, but we'll get it packaged for you. The paper discovery so that when you pop back on the bus today to head back to Rice Street, you'll have it. All right? Thank you, Mr. Biden. That'll be very helpful. And we do have court at 1.
Back at 1 o'clock, back in the future.
You may. Thank you.
Thank you.
All right. That takes care of Mr. Mosley's position.
Oh, yeah.
His wife came there.
Judge, are we doing a pre-trial meeting today?
3:30.
3:30.
Hey, have you guys appreciated the Easter Bunny loaded up the dishes?
How come it was only on this table?
Sorry, I knew it, yeah, anyway, so,
Oh. Okay, anyway, that's, I put one on both tables yesterday. It's mostly from Ms. Niles, taking away from her kid. I think Mr. Leak is it, so let me find out, from Judge Ingram. Mr. Glenn, you're still here.
Yes, about a week. There's these, he's over in Oconee. And I said, take care.
Okay.
Yeah. I'm gonna message them too, right? And I said, I'll get something today. And if it's say, well. Really? Did she cry at home? Okay, yeah, that's kind of hard.
She cried from like 1 a.m. She was like, maybe she did a training because she was kept saying, you know, that you're sick.
Oh, no.
And I cannot get out. I had to get Minnie Mouse. I had to look up to the line.
Yeah.
Thank you.
I don't want to find it.
No, it's fine. I would.
It's not you.
That would be.
Maybe she's having dreams about getting bed.
Yeah, it might have been traumatic for her. She's probably fine. Like kids are different. She's probably gonna do it.
So visual.
I totally forgot.
I'm pretty good on.
Mr. Leak, would you prefer to come back at like 12? Ms. Wood is stuck for like another 15, 20 minutes in this other courtroom. We could just do our lunch break now. I know you got all these folks here. We could just, I'm gonna go back and do some work and I'll come back when Ms. Wood gets here. Or we could say, let's just do our lunch break now and we'll come back at 12:45 instead of 1, and you'll be the first thing we do at 12:45. I'm deferring to you because you've been stuck sitting here all morning. We're going back and forth here. I just soon take the pressure off Ms. Wood and say, take your time and Judge Ingram. And so you guys can go get lunch at American Deli or something or whatever, and just be back here at 12:45 and we will handle your situation then.
All right, yes, sir.
Okay. Yes, ma'am. Thanks. We have you all day?
You do.
Excellent. Mm-hmm. We're suffering.
For the 1 o'clock calendar, Cecilia Fletch has been reset, right?
Right. Well, I was going to ask you that. Any update on that?
Yeah, I haven't been able to connect with the federal prosecutor, but
They're busy deporting everyone. Okay. But no, Ms. Futch shouldn't be here. She's in Florida?
Yeah, she's in Florida.
So that's off because I think you have basically said, let's hold off on doing that, to see if the whole thing gets resolved.
Yes.
Okay.
I don't think I need to come back unless y'all need me.
No, will you text Ms. Wood though to let her know, that she doesn't need to rush back? We are resuming at 12:45 with Mr. Leak, and I let Mr. Leak go to lunch.
Okay.
Thank you.
Judge, you don't need me to come back because, my understanding, everybody else.
We always need you back, but none of it is a possible
But
plea.
everybody else, well, I can argue.
Let me look. So this afternoon, 2 juvenile bond hearings, and Leak won't be you, and is Cameron Wright a kid also?
Yeah, that's the one that.
Oh, right. Yeah, that's it. So you are good to go. Thanks. Where were people yesterday for Judge McAfee? Were you involved with that?
No, I was studying Kraus, 20 inmates.
Oh, that's a lot of inmates. Yeah.
So she had about 20 and William had about, we had to clear a tank, so it took us forever.
Ms. Wood, good to have you back. Did the pleas go through?
Yes.
Three things. One, the Easter Bunny stocked those,
Thank you.
just reciprocating. Two, but I think you already learned about this. Some documents came in. You had a chance to review those? Okay. And then three, this is a good news, bad news. I think writ large it's good news, but Mr. Mosley and I had a long conversation. After getting him off the groove of, but I need a real lawyer, he came to appreciate the wisdom and value of having you as his lawyer, and withdrew his request to represent himself. He did say, well, if my family hires someone, can I do that? And I explained, sure, if that person is ready to go when that person shows up. I don't get the sense that that's going to happen. He just wanted to know if he's locked in. And I said, he's not locked in. And Mr. Abate is going to be back at 1-ish and is going to have the paper discovery. Mr. Wood, asked about when could he get discovery. What he really said was, when are you going to rule on some of my motions? And I said, it depends. What are your motions? And one of them was, I have a motion for discovery. I explained how much discovery these days is digital, and then you or an investigator would undoubtedly be connecting with him soon to watch videos. And then Mr. Abate popped up and said, hey, how about I get paper discovery, which was huge. And it will include the This Just In ballistics report, which wasn't so perfect for the defense, but is what it is. And Deputy Gordon kind of committed to keeping him in the building so that he could get that stuff today. Did we keep?
Yeah, he said,
Okay, good. So those are my updates.
Thank you, Judge.
You bet. We are going to talk about Mr. Leak now. Before he comes up, for those of you who are here for Ms. Cabrera's matters, we're going to do them. She asked that we hold as close to 1:30 as possible, but I guess that's, Mr. Abate's not here yet, and that would be you with Mr. Mender. Okay. All right. And are they here? Did the juveniles get brought over, or maybe their lawyer waived their presence?
I know they were picked up about 12 because they called me from the facility.
Oh, okay. So they're just not here yet. Their calendar wasn't till 1.
I don't know.
Mender's the only one that you have.
Oh, Williams isn't here, or Williams isn't? And what about Wright?
Right, he's up there.
Oh, Wright is here. That's right. And Ms. Gordon is going to handle that. Okay. And maybe Williams isn't a juvenile. I don't think he is.
Amori?
Yeah.
No, he's an adult.
Okay. Then it's Mender. That's it. Okay, great.
Only one for, yeah.
Yeah. Okay, so we will get to those, and we may do, if we get Ms. Gordon here sooner, we may do Wright first if we don't have Ms. Cabrera. But what we'll do now is Mr. Leak.
And I was gonna let you know, Ms. Gordon is making an announcement and Judge across the courtroom, and then she'll be here.
Okay, fantastic.
I'm gonna head that way, Your Honor, and I'll be back.
All right, as long as you come back. So Mr. Leak, why don't you come on up to the table and sit with Ms. Wood.
I did reach out to Miss 88 Clark, but.
Oh, right, we need her, not you, right.
Yeah, I just didn't know.
That's 7E, man. Let's get rid of that place. Okay, we're so close. Well, let's just hold then, and we'll wherever we get the first complete set, if we get Ms. Gordon, is Mr. Wright here now? He's here, great, okay. Except do we need Ms. Singleton for that? We do. And she stepped out. So when we get them back, so we'll just sit tight. So Ms. Clark is with Judge Ingram, but we may be able to pry her out of there. What case are you here for?
I'm here for State versus Cassell's.
I don't know that we have that today.
I just saw that under the general docket for Mr. Cassell's case. I thought this was a general motions calendar, but I can be mistaken.
So did you file any motions in his case?
I did, Your Honor.
You did. Do you have the case number?
I can give you 1 second, Your Honor.
Great.
Um, 24 SC 004759.
Interesting. You filed a motion to suppress the search of the house. And the scheduling order says if you filed a motion like that, it would be heard today. But we didn't end up publishing the motions calendar. Did you send, when you filed that motion to suppress, a courtesy copy to Ms. Nelson?
Your Honor, I did not send a courtesy copy to Ms. Nelson. I'm assuming Ms. Nelson is the
Litigation manager,
yeah,
the brains of the operation. Okay, that explains the disconnect because she doesn't scour the docket for motions. My standing order says if you've got a motion, of course you need to e-file it, but you also need to send a courtesy copy to Ms. Nelson so she knows to calendar it. So that's on you, but that doesn't mean you've waived your client's rights to have the motions heard. What I'm going to ask you to do is buzz your way back there, get with Ms. Nelson, and we'll figure out a time and place to calendar that motion so that the state has notice to subpoena officers or whatever they think they need, and we will go forward with the motion.
Yes, Your Honor, and if I may just briefly ask, I'm assuming no officer showed up because I actually sent them my own subpoena for the officer to see.
I haven't turned anyone away. Deputy Gordon lets anyone come on in the courtroom. Was it 1 o'clock?
Yes.
Okay, they may be trying still to get in the building. So if you want to wait for a little bit to see if anyone shows up, you can let them know what the deal is. I'm happy to say, my bad, we didn't schedule it right. But before you leave the building, you should definitely connect with Ms. Nelson to talk with her about scheduling so we do get this heard. How long do you think the motion would last?
Not long, Your Honor. I think it's going to be dispositive one way or another within 10, 15 minutes. The facts are pretty simple.
So they had an arrest warrant, not for your client. This is, as you understand the facts.
I understand.
Okay, and your client answers the door, says Miller's not there, and they might have gone in anyway to find Miller, as you understand the facts. And so what are you doing? Your warrant doesn't get you in the house if the person says he's not in the house. Okay, got it. Is this ringing a bell? Still a bell?
Looking at it and being like,
If those are the facts, that's it. Okay, got it. And it was Mr. Cassell's house where these officers knocked.
So Mr. Cassell's, he was staying there. I know this is not on the body cam video, he's wearing sleeping robe and everything. That's where he was staying at the time.
Got it.
Where he was kind of transient at that.
It was his residence at that time.
Yeah.
Got it. Okay. Well, that makes for an interesting twist to the facts, but got it. So we definitely need to have that motion hearing. And I leave it up to you whether you want to wait a little bit for officers, go see Ms. Nelson, come back, but please talk to her.
Yes, sir. I'll stick around for about 10 minutes and then I'll go talk to Nelson.
Great.
Thank you, Howard.
Thank you. I'm glad I asked why you were here.
Or radio silence when I want to.
Yeah. Ms. Clark, thank you for corresponding. That allowed me to reach out to Judge Ingram to say, hey, we just need 15 minutes and then you can take these pleas that may take longer or a plea. So now let us turn to Mr. Leake's case and let's get on the record. This is position 1 on our add-on from this morning. The case is 24 SC 004712, State versus Broderick Leake. And he's represented by Ms. Wood, who is here. Ms. Clark is representing the state in the case. And when we were last together, I think it was a final plea, I learned about an additional arrest Mr. Leake had. And that got me to looking at where we are with bonds and what happened when. And I want to have a discussion about the wisdom and propriety of leaving Mr. Leake on bond for the case that has been indicted and is on an upcoming trial calendar, the 24 SC case, in light of the more recent arrest. So let me tell you what I understand the facts to be. And these aren't the facts of this is what the case is about. They're procedural facts. Then I'm going to hear from Ms. Wood and her client if there's things he wants to add, and then Ms. Clark. So Mr. Leake, the case that we will be trying involving allegations of child molestation, the alleged conduct was in October of 2022. For a variety of reasons, you were not arrested until December of 22. And you posted a bond, or you were granted a bond. You were granted a bond that same day or thereabouts, $150,000 bond with an ankle monitor. And I think you were in for about 9 days and you posted that bond, you got out. That bond has a number of conditions, one of which is don't get arrested again. Fast forward to this year. And on the 30th of, let me look this up, January of this year, something allegedly happened and you got arrested the next day. I'm just looking up what the something is. All right, this is you and Mr. Smith. You and Mr. Smith get arrested. It's marijuana, another type of drug, and an expired tag or no decal on the tag. So you're on bond for a pretty serious offense and you get arrested. And even though you're on bond, some judge said, let's give him another bond. And so at the end of January, you got a real small bond for your new arrest. And I want to work through whether your bigger, older bond ought to be revoked because you got arrested for criminal conduct while out on bond. It's that simple. Ms. Wood.
Yes, Judge. So we're asking you to not revoke the bond today. He was doing well with the ankle monitor since he bonded out way back in 2023. I'm not sure why the ankle monitor was removed at Rice Street when he was booked in previously.
Oh, the January arrest resulted in the ankle monitor. I wasn't bringing this up because of ankle monitor concerns, and if it got taken out by the sheriff, that's not Mr. Leake's fault. But when he got booked in, and it looks like he was in for a couple days for this drugs and bad tag, he had his ankle monitor taken?
Yes.
Okay.
So if it would make the court more comfortable and leave bond in place, Mr. Leak would have no issue going back on an ankle monitor. He had no issue, so it looks like he actually bonded out in 2022 up until earlier this year. So he was out on bond for a good while without any issues. He was compliant with all the special conditions. I do realize that getting arrested is considered a violation of the bond. However, there are actually, just looking at the warrants, there's actually multiple people involved, even though only one person was charged.
Well, it looks like two were. There's this Antonio Smith who, and maybe that's been thrown out, but if you type in this PI number, two names come up. And it's not an alias, it's another guy.
And then there's a lady that was not arrested.
Okay.
I believe it's right over a misdemeanor amount of marijuana, if I remember correctly, and I think it was found in the trunk of the vehicle. So there's lots of arguments to be made at the appropriate time on that case, Judge. But I say all of that to say he's coming to every court date. He has his family here with him today. He's working. He's gainfully employed as a barber. I think since we're already on a trial calendar and we're pretty much ready to go, I think it would not do any. But he hasn't had any issues complying with maintaining no contact. So I think it doesn't harm anyone to keep him out on the streets, Judge.
Okay. I'm reading the affidavit in connection with the recent arrest. So there were guns in the car. There was a rifle that was under Mr. Smith's foot, it says, and then drugs packaged for sale, not a ton, cash. And then there was a pink pistol that was given back to the female. So the female had a gun that she claimed, and then there was this rifle that was under Mr. Smith's foot. I can't. Okay, someone ran and kind of fought with the police, but that was Mr. Smith and not Mr. Leak. But I got to tell you, Mr. Leak, and I'm going to hear from Ms. Clark in a minute, is pretty bad optics. You're in a car with a rifle and a pink gun, drugs, a passenger in your car. It sounds like you were the driver, but I'm not pinning anything on you. This is just the affidavit. But the guy in your car bolts, takes the police on a chase through a building, this and that. The drugs in the car, these two guns. Tough spot for you to be when you're on bond for child molestation. Yes? Yes. Okay. Ms. Clark, your thoughts?
Your Honor, state wholeheartedly agrees.
Well, there's not an agree. It's not an agreeing. I'm not sure what to do here. I think Ms. Wood makes some good points. Most of all, none of this is being around the alleged victim or the victim's family, but it's making some questionable choices for someone on bond.
Right, that's the concern there. There was the defendant has had a prior arrest, although it was dismissed in 2020 for drugs before. So this is not like the first instance. And I mean, the state is concerned about that. We have not, I've not talked, the victim has not reported any contact, but if the defendant would remain on bond, I would think it would be arrested, him having the ankle monitor back would be appropriate.
Step on the courtroom.
Ms. Wood, is it okay if I ask your client a few questions just about his work?
Yes.
Okay, Mr. Leek, Ms. Wood said you're a barber, correct?
Yes, sir.
Do you have your own, don't hate me for using the wrong term. Do you have your own salon or barber shop? Or do you have a chair in someone else's space?
Mobile.
Mobile?
Yes.
You go to people?
Yes, sir. All around.
Okay. People don't come to you?
No.
Okay.
Every client I have.
Pardon me?
I go to every client I have.
Okay, but it's always you come to my house or something. It's not, let's meet you at Fred's barber shop, because I know Fred, he'll let me use the chair.
No.
It would be you'd come to my house or whatever.
Wherever you work, wherever, it doesn't matter.
Okay, and on a given day, are you doing 10 or really it's just you do one a week, or what would you say the volume is?
Like 6 or 7 a day. If that.
Okay.
It varies.
Okay, I understand. No 2 days are the same. Are they mostly in Metro Atlanta, or you're driving to Savannah and in the same day you're going to Tifton?
Mostly Metro Atlanta.
Okay. So you're going to be back here on Thursday for the call of the trial calendar. And right now, no ankle monitor because the folks at the jail took it off you.
Yes, sir.
All right. Okay. Mr. Leek, I'm going to get the ankle monitor back on you, and I am going to do one other thing. I am going to put a curfew on. You can leave the house for any reason during the okay hours, and then you don't leave the house for any reason during the not okay hours. This gray Avenger that had you, Pink Gun Lady, and Mr. Smith got pulled over at 8 p.m. So what I'm going to do is set a curfew from 7 p.m. to 7 a.m. So you have to be at home during those 12 hours. Sure.
I don't close, me personally, I don't close my business until 10 o'clock p.m. So after that, I don't have no more haircuts.
Okay. This happened at 8 p.m. You're not going to be rolling around in an Avenger or driving one at 8 p.m. So 7 to 7 is when you can be out and about. And you'll get the ankle monitor back on. You'll have the same stay away provision of no contact with Kaylee Jones and her mother. I noticed you had a whole fleet of kids with you. You're not supposed to have contact with any kid under 18 without another adult being around. How's that going for you? Okay.
Whenever I have my kids, somebody would.
Okay. All right. It'll still be a county funded ankle monitor, but I'm going to, as a result of this arrest, add that curfew provision. And you should know Second Chance is pretty good about shooting me an email when there's a violation, and their monitoring will be pretty simple. If the monitor registers as not being at your residence after 7 p.m. on any night, and I was going to the emergency room because my kid bumped his head, then we're done with bond until we sort your cases out. And I'll make sure they've got a good address. The Antebellum Circle, that's where you live?
Yes.
Is that where you want it to be for each of the nights?
No, sir.
So I'm not gonna get into your personal business, but you can't have multiple bedtime addresses while you're wearing this. What's the address you're gonna be at from? And is the address you're writing down where we should mail notices?
No. I have all my mail at my mother's house.
That's the Antebellum Circle? Okay. but what the bond order should say is that you should be at whatever address you're writing down from 7 PM to 7 AM, and that's where you'll be?
Yes.
Okay. Is that in the metro Atlanta area?
Yes, sir.
Okay.
Yeah. What is it, 1070? Is that look right?
Yes.
Okay. 303.
All right, Mr. Leak, you'll get information probably from Ms. Wood about when you need to connect with Second Chance. Is that whose ankle monitor was on you already, was Second Chance? So you know where their offices are? Okay, well, she'll shoot you an email or give you a call as to when you need to be there, but I'll be letting them know, hey, Mr. Leak needs to be to your place by this date. So they'll let me know if you don't show up, and then we'll be where you don't want to be. Do you have any questions about how we're changing things in terms of your bond and the conditions of the bond?
It was just about the hours on.
I got it. I heard you clearly. Ms. Clark, anything else from the state?
No, Your Honor.
Okay, then I will see the three of you in just 2 days to talk about where we are on the trial calendar. Ms. Wood, anything else on behalf of Mr. Leak?
Yes, Judge, actually. There's it's like potentially an active warrant from the ankle monitor compliance calendar. If you remember, the last time we were here, I had asked that you be excused from that. And it looks like Judge Manning still issued a warrant.
That's why there's a W on the calendar.
Yes.
Okay, and your understanding is that that popped up because Mr. Leak didn't go to the compliance calendar, but you told him he didn't. I'm not fussing, but you said, don't worry about going to it. I've talked with Judge McBurney.
Well, we brought it up when we were here and we discussed, like, if he doesn't have an ankle monitor on time, it didn't make sense for him to go, because I believe we were here in court just like a week before that calendar.
Mm-hmm.
It was April the 14th, and then it looks like the warrant was issued a week later.
Do you know why his case was on that calendar?
That-
Just because of the age of the case,
And
maybe?
it was on, I believe, because I'm not sure how they process those calendars, but for whatever reason, I think they still had him on a list for an ankle monitor.
Okay,
So what was determined last time was that they put him on the list because it was showing that his monitor wasn't on. But you were able to ascertain from his statement that when he was released from jail.
got it. In fact, wasn't on, it was sitting in a bucket where they gather them at the jail. Okay, I will take care of getting that warrant set aside so that doesn't create any complications. And I'll enter an order that modifies the bond, and then Mr. Leak, Ms. Wood will let you know, or I'll tell you on Thursday if I find out by then, when you need to go back to Second Chance to say, I missed my monitor, can you give me another one? And they will do just that. If that is it, you're good to go.
Thank you, Judge.
Ms. Wood, I guess I'll need that. Are you want to email that address to Ms. Nelson?
I just sent it to you, or I'm sending it right now.
Okay, yeah, include me, please.
I'll be back, Judge McBurney, in regards.
Thank you. I'll see you then. I'll let Judge Ingram know you're coming.
Yes, sir, thank you.
All right, let me check Zoom. No Cabrera yet. Mr. Abadi, did you bring that discovery?
I already gave it to,
Deputy Gordon?
yes.
All right, it's going where it needs to go. Thank you. I let Ms. Wood know the good news, she's back in the mix and that you were bringing some discovery.
Ms. Wood's credit, I think she's already given it to him twice, so.
Okay. So I guess we're on hold. Hopefully you all are here for Amori Williams, Quinard Mender, or Cameron Wright. Anyone here for anything else? Yeah, you're here, I understand, but as long as you're here for one of the, that's all I've got left of those three. We're just waiting on two defense attorneys.
May I be excused?
Yes, ma'am. I will see you tomorrow. Maybe. Do we have criminal tomorrow?
I think we have a pre-trial conference this afternoon.
Oh, yeah, at 3:30. I'll see you then.
Yes.
And then there's an evidentiary hearing on a revocation.
Tomorrow morning or tomorrow.
Tomorrow afternoon. I'm just seeing who the lawyer is for Ronquel Green. Melnick, okay. And then someone withdrew on Stevenson. Or Alexander, whatever, and Ms. Rios did. And so what are we gonna do the revocation tomorrow? So he'll be brought over or be virtual and we'll have the lawyers and we'll work through it. Okay. Were all those people here for Mr. Leak? Oh. Okay.
Judge, what happened with Samuel Jones this morning?
A year.
I revoked 1 year
Okay.
and terminated the probation after that. So he's not back. He got 14 years probation from
You didn't handle, that was, okay.
Ron Jones?
No. Xavier Mosley didn't have a probation revocation today, right?
No, Mosley was just Ferretta. All we did was Ferretta got to the very end and he said, you know, now that I think about it, I think I'll go with that Ms. Wood. All right.
Thank you, Judge.
Yeah. He had watched some of a trial on CSI. So. Did you deliver the package?
Oh, I left it right.
Where you been?
Juvenile.
Oh, is he up?
Yeah, he's up.
Okay, well, we don't have lawyers yet, but
Oh, I can run out.
yeah. So you went all the way down there without that? You just like riding the elevator. This is your way. Now he does. He's not the model of efficiency. Hi there. Did Mr. Chang come back and see you?
He did. Told him he didn't follow as much as
Yeah, he didn't.
two things, finally, and give it me.
Right, right. But it's an interesting suppression argument, so we need to have the hearing.
He's gonna be on for the 27th.
Great, okay.
Where's Miss Wood going?
She's done. She'll be back at 3:30, at least virtually.
Days, I heard you talking about Mr. Green. Is that gonna be an evidentiary for?
I think so. I'll ask Ms. Dilligard.
Stevens.
No, that's gonna just be a revoke me, please.
Okay.
So just Green.
Okay, so they're gonna bring those.
Are they being brought over? Okay. Ms. Dilligard, did Mr. Melnick say anything to make you think that Green will not be evidentiary? Or as far as you know, you'll have witnesses and we'll do whatever we need to do?
Witnesses
subpoenaed, and expected to appear tomorrow. I haven't heard from him as of lately. The last time I heard from him was through Miss Wood about this case, so
About Green? And what did you hear?
just that he was going to be taking care of the case, and that's as far as it's gone.
Oh, okay.
But I will reach out to him again today.
No. I mean, he's on the cat. We're bringing Green over. I just was curious if he had, I don't remember what the underlying, is it a drug case that's the underlying offense? I can look it up. Yeah, he was arrested in Clayton County for possession of meth with intent to distribute, had a gun, also cocaine. So this should be 15 total charges, it says.
Yeah.
So you'll have a Clayton officer or two, and we go from there. Okay.
That's right there. Maybe. That's how it was. This is not one of the takes it. It's not working. Yes.
But anyway, yeah, walk.
Did you bring both envelopes down?
Only one. Appreciate the letter.
Yeah, she's on. It is. Where is that candy?
What was that?
Ms. Dilligard, do you remember what Ms. Wood or Ms. Rio said about Rachel Gore? I guess we don't have Ms. Singleton either, so we're stuck until they both get here for right.
She was in crafts, what did you say?
Okay. Hey, Ms. Gordon.
Hello, Judge.
We are waiting on either you or Ms. Cabrera, and you got here first. Do you need a little time to speak with Mr. Wright?
No, Judge, I spoke with him yesterday, I'm ready to go, and Judge House is expecting me back downstairs, so.
Great. Well, let's be efficient users of your time and Ms. Singleton's time. Mr. Wright, if you'll come on up and sit between the two women at the desk there, please. All right, let's go on the record. This is 22 SC 183909, State versus Cameron Wright. Mr. Wright is here in court with Ms. Gordon. We also have Ms. Singleton here from pretrial services. And we have Ms. Dilligard for the state. And we're here, Mr. Wright, because a different prosecutor, Ms. Trotty, Trotty, filed a petition to modify or revoke your probation way back in August of 2023, so 18 months ago or so. And in it, she reminded me that you were sentenced in September of 22 to a little bit of time in custody and 7.5 years on probation. And she filed this because she was concerned about an arrest you had in June of 2023. You were supposedly arrested for theft by receiving stolen property. That property, unfortunately, was a gun. And you were also arrested for possessing a handgun while being under 18 years of age. So we had that situation. I don't know why we're only talking about it now. I'll be interested in hearing from anyone involved as to why only now we're dealing with this. Not because I want to fuss at anyone. It just makes it less impactful to be talking about something that's this old. In particular, if what I hear from Ms. Singleton is that you've been out of trouble since then. If other things have been going on, and we'll talk about all these things, but that's my understanding of what we're working through. And we did talk, Ms. Gordon, I think if I'm remembering correctly, last time, and this was when Mr. Wright was not represented, so we didn't get substantive, but Ms. Singleton let me know that I think she was going to be asking to have a few aspects of Mr. Wright's sentence modified, like graduating or getting a GED. There were some goals that were set that aren't ultimately practical goals, and rather than creating frustration and impracticality, Ms. Singleton was going to ask that I look at that as well, which I'm happy to do. So I think I'm going to turn it over now to you, Ms. Gordon, unless you want Ms. Singleton to start by saying, here's what I think is going on, and get your input as to what you think ought to happen as a result of what's been going on. And then I'll hear from Ms. Dilligard.
I think I would like Ms. Singleton to go first.
Okay. You jump in first, Ms. Singleton.
Yes, Your Honor. You want me to start with the petition, the dates?
Yeah, if you know why we're only talking about this now, and then, so one, why are we talking about it now? Two would be, what if anything happened with those allegations? And then three, what else are we adding to the mix? Are there conditions we ought to remove? Are there other things that have been concerning you or pleasing you with how things have been going with Mr. Wright?
Yes, Your Honor. So, Your Honor, Cameron, as the court is aware, is under a probation sentence that I am supervising because of his age. He would not start going to the adult probation with community supervision until his 17th birthday, which is in December of this year. He has been under my supervision since he was released. When he received the new charges, I contacted Ms. Trotty because she was still here in Superior Court, and she filed a petition. My expectation, I don't know what the process is when petitions are filed, but my expectation was that it would be calendared for the revocation hearing in fairly short order, and we would address the issues at that time. Because I am a pretrial officer and not a probation officer, one of the situations that occurs with these courtesy supervisions is the DA's office would typically file the petition as opposed to probation because they have nothing involved in the case, and we would go from there. The case was not ever calendared. There was a little bit of communication that I was having with various DAs that are no longer here, and the case was just not getting calendared through these years.
Okay.
And so I sent an email to Ms. Nelson and asked her to please calendar it because we needed to address the things that are not possible. And I needed the court to assist with some communications with Cameron.
Sure.
We're trying to keep him, I guess, in as much compliance as we can to try to get this situation resolved.
Okay.
And so I used this as a mechanism to get him on the calendar.
Okay. So my guess is then what happened was that Ms. Trotty filed this, but didn't tell anyone on my staff. And we don't have a mechanism where a red light goes off saying, hey, because it doesn't flow through a DCS channel. We know because someone gets arrested on a warrant and they hit this. There was no arrest in connection with this petition. It just sat on the docket until someone said, Ms. Nelson, this is an actionable item. And I appreciate you doing that. Maybe that Ms. Trotty didn't know that she needed to reach out, but I am confident had she or a colleague said, Ms. Nelson, please put this on a calendar, it would have gotten on a calendar. These seldom arise. And so my guess is there's just not a routine for people. And they thought, hey, we put it in the docket, so something will happen. But that's not how the docket works. But here we are.
And that is correct, Your Honor. This is the first one I've had in all the years that I've been doing the courtesy supervision. So there wasn't any way for us to know what to do. And this trial was immediately thereafter the SB 440 unit was dissolved and the DA's office had started and she was sent to juvenile court.
Okay, so there was,
There since then.
okay.
So that explains that situation. As to the charges that were laid out in the petition, Cameron did receive a sentence down in juvenile court that included 5 hours of community service and a diversion program. He completed everything, and his case has actually been sealed and closed there. He was the dismissal, they considered it a dismissal because he completed everything that he was supposed to. And that order was actually filed in January the 5th of, looks like 2024. January 4th of 2024, the sealing and dismissal was signed by Judge Yogo. So that resolved the charges. During the time that Cameron has been under my supervision, it's been a lot of activity. Cameron has these are the only charges that he's received. He started out with me in 8th grade at Drew Middle School. He was residing with his grandmother at the address that's listed on the sentence.
Okay, the Riverdale address, we talked about this last time. He is there, just not with his mother.
Correct, his mother does not reside there and she was temporarily residing there at the time of the sentence. So that is the grandmother's actual address. He resides there with his father who's in the courtroom, and at least one other brother. There may be other siblings at home, but he resides there and he has resided there probably about 75–80% of the time that he's been under the sentence. The charges arose from when he was residing with his mother at an apartment complex here in Atlanta.
So you're giving him like an 80% compliance rate. Where is he residing when he is not at the Riverdale address?
Wherever his mother resides.
Okay, and you're
Either, and I'm always aware of where he's at.
okay.
I'm always in communication with him and it's very easy for me to go and see him at any location.
Okay, so when he's not at the Riverdale, I'm sorry.
Seeing him has never been a problem.
When he's not at the Riverdale address, it's with your knowledge?
Yes.
Okay.
Yes.
Do we need to eliminate that as a condition of probation? Or do we say your primary residence should be the Riverdale address or have no condition about where you stay? Because he's technically violating it. It's not troubling me, but he's technically violating it when he is staying with mom somewhere else. And I don't want to prevent him from staying with mom if that's a healthy place for him to be or necessary because dad can't manage it all the time.
It probably would be in his best interest to remove the address condition. It is not a healthy environment for him being his mother's, in my professional opinion. However, there are circumstances that lend to him having to be there sometime.
Okay.
But all of our problems seem to arise.
When he's with her?
Yes.
Okay.
And I had hoped and encouraged her to be here today. But she has not. She was not here last week.
Okay.
So the most troubling things that have occurred during the time that he's been under supervision have been school related, which is why I've also asked that the condition be removed that he receive his high school diploma. As I said before, the court is aware he was considered to be extremely academically strong, and that is why the court only allowed a high school diploma. However, now he would not be allowed to finish in pretty much any school setting because of the grade he considered in. We started off in 8th grade. He was fairly quickly tribunaled out of that school setting by Drew Middle School based on his behaviors and fears and concerns that multiple people had at the school. He ended up going to I'm sorry, I'm saying Drew Middle School, but that was not the name of the school. It was a middle school in Clayton County. Sequoia Middle School. He then mysteriously managed to get into Drew High School, which was, I was very excited about that. He was, I believe, very excited. We had bounced back and forth between being expelled and suspended and kicked out of that high school since he went into the 9th grade, typically for aggressive acts, continually against other students, sometimes verbally against teachers, threats, fights, a variety of things. So we're just not progressing. They sent him to a special program. He halfway finished the program, but they still let him come back. The principal, I had a long talk with the principal. He really liked Cameron. He felt that there was a lot of things that Cameron could accomplish. However, his behaviors continue to interfere.
Okay. So it would be then not graduate from high school, because the current condition is must enroll and remain in school and graduate from high school. Strike that, replace it with get your GED.
Yes, we would replace that with get his GED. If the court does not consider a custodial sentence today, then I would like to change the structure of the conditions as we're stating with getting the GED. I want to place Cameron at the Promise Center. I've spoken to his father, I've spoken to Cameron. Cameron has done all the legwork with his father being the driver and having to show up as well. He has signed up for the mental health at Chris 180, which is part of the at Promise Center. One of the things that has happened is there have been police phone calls constant by his mother to try to have him arrested for a variety of things that she states he has done.
Meaning mom calls 911 saying, you got to come get my kid. He's doing X, Y, Z.
Right. And then I tell her to call me when the police get there. And when the police get there, then they get on the phone and they have a little different version. Cameron's never been arrested. However, the police did a referral to DFACS. And DFACS did a trauma assessment, which I was hoping would lend us to something to explain some of the behaviors at school. They put him in therapy. He completed the therapy with them, but I think that Cameron could benefit from an additional therapy, which is why I suggested Chris 180. Since Chris 180 and the Promise Center GED are in the same building, I thought that would be very helpful as far as transportation, as well as they have a teen summer camp, which is one of the few that I've ever seen. And I've had people participate in it and they like it. He can do community service there because he has 120 hours of community service.
So he's done 0 of that.
He did 5 on the juvenile case. I was gonna try to let that slide over.
I don't think that's
it
that
doesn't
bad.
matter
Okay.
at this point. So he has 120 hours. He can do the community service there. He can participate in the teen camp if that would be optional if he wanted to have something to do during the day hours. He can go to the GED program, which runs through the summer. They don't take a break. They also are connected with mentoring programs such as Let Us Make Men, where they will actually give Cameron a mentor. They just contacted me last week about a program that they're getting ready to start and asked if I had any young men that I thought would be interested. Well, they will pair him with a mentor that will stay with him for 1 to 2 years, help him through school, get him in trade school if he wants to. And so I am going to refer him to that if he is allowed to remain out. And that would start in June. So I think that we need to just go a different route and find out maybe what some of the underlying problems are. His father is in the picture and is doing a lot of things with him now. And I think that's been very beneficial. He's been willing to take him places, get him signed up for things. And there's lots of appointments and a lot of things that would be required of his father, which I've told him this would require a lot from him. As well as he has a younger brother that's disabled that's in the home that was here last week. So his father is also responsible for him. I believe that Cameron can get the GED and finish the community service before his 17th birthday.
We could create a stretch goal.
I think we still have time to get it done. Cameron did not get, he listens to the things I've told him to do and he will start off with an effort, but he did not really, in my opinion, seem to take this seriously until this court date was set. So I would request that he receive court dates for statuses and they be short order. I know that that's a lot for the court, but it seems to be the only thing that has gotten him motivated in these 2 years that we've gone through this.
Because otherwise, I mean, he benefits from your commitment and your flexibility. And this will change in December when this sentence flips over to something supervised by DCS, they just send me a warrant to sign. Hadn't done probation, hadn't done community service, still doesn't have GED. And we don't have a little conversation like this. I sign the warrant, he bumps into the police, he his mom calls the police and they can't walk away if there's a warrant. They may find that there's no substance to mother's complaint, but they run his name and there's a warrant. And then you sit in jail for a month until we end up talking about the revocation. So this is an opportunity to get some things done. And I think having a court checkup makes a ton of sense in lieu of your ability to, I mean, yes, you can through pretrial, I guess, swear out a warrant, but that's not the way you tend to do things. And so I think court status checks make sense.
Yes, Your Honor. And so that is the idea that I had of a plan for what could possibly work for Cameron if the court allowed him to continue under supervision. I would like to turn him over to probation with everything done, so that he at least had done everything. That is the things that I think would need to be put in place for him to be successful.
And the LEADS program and juvenile initiative, we can strike that because one, that ship has sailed, but I think you said those are both defunct.
Correct, Your Honor. My understanding of it, we're talking to other DAs, is that those programs don't exist anymore. And that they didn't exist very quickly because he had 60 days, I think, to decide what he was gonna do, and
Right.
he was already gone, is what I was told.
Okay. Wonder where we came up with those. Okay. At Promise Center. And how do you structure a condition? It would be sort of akin to attend LEADS program. It would be attend the At Promise Center for GED classes and Chris 180 counseling. I want the conditions to be specific enough and also directive enough, as opposed to, hey, it would be nice if you did these things.
Yes, Your Honor. That he attend the Promise Center GED program and complete it. And that he participate in the Chris 180 mental health services until other directive from the staff there, the counseling staff.
Okay, and the Chris
They
one.
will put him on a detailed plan and they will let him know the plan.
And that Chris 180 treatment can occur at which At Promise Center is this? Or do we not care? He should just go to any one of them?
He will, so the classes are on Monday and Wednesday on Hamilton Road. I have the exact addresses, and then Tuesday and Thursday on Metropolitan.
So he'll bounce between, hence the driving for dad is that he's not going to the same place every time. But it's At Promise and they'll keep track. They're gonna, even though he's going to a different At Promise Center, they'll know, hey, this is Cameron Wright. He's doing some classes at Center A and other classes at Center B.
That's correct, Ron. It's the same 2 teachers.
Okay.
For each, and it's just that they're teaching 2 subjects, math and science at one and language arts and
Okay.
at the other. So he would have the same teaching staff. I pop up there regularly. They contact me often about my clients, and they have a lot of things that they offer. And people do get their GED. And they also give them scholarships for trade school, tech.
Oh, At Promise is a impressive resource. It's ironic origins, but it's great. I mean, it is a happy confluence of a bunch of things. So that works for me. Mr. Wright, have you been following what Ms. Singleton's been saying?
Yes, sir.
Any questions about what she said? Have you been to the At Promise Center before? Okay, do you know what it is? Kinda, okay. Ms. Gordon, you wisely let Ms. Singleton go first. What, if anything, do you want to add as to how we work through this? And again, it's technically on for a revocation. I don't know how you want to move forward with that. The basis in the petition, so the only thing that would, I'm not saying that these other things that Ms. Singleton has identified aren't issues, they just aren't part of the petition. The basis of the petition is a case he's already resolved.
Right, Your Honor. So I'm in agreement with Ms. Singleton. I spoke very briefly with the state just when I sat down here, and I understand that the state may be asking for a revocation of actual time to serve, which I don't think is appropriate in this case. If you recall, Cameron was only 13 years old at the time of the incident that led to this case. I think he was 14 years old when he ultimately resolved his case. And like you said, that juvenile case that arose in 2023 has been resolved. He took responsibility for it. He completed everything he was supposed to complete per the juvenile court. And that case has since been dismissed and sealed and closed. The other issues that Ms. Singleton brought up in terms of the fights and things like that at school, it sounds to me like those may have been, at least in part, a result of the environment that he was in at the time with mom. He is not in that environment anymore. His dad has just.
Well, he is, I'm sorry to interrupt, but it sounds like, unfortunately, he is sometimes. A fifth of his life is with mom.
It sounds to me, Judge, as though, so dad just came back into Cameron's life in March. And it sounds as though dad is going to be taking over as the primary parent and the primary caregiver at this time. I spoke yesterday evening with Cameron and his dad. His dad expressed to me, I said to both of them, what can we tell Judge McBurney tomorrow to ensure him that you're going to stay in line, that you're going to follow your probation requirements, that you're not going to get in trouble at school or anything like that. And one thing that dad said, and dad's right behind us here in the blue shirt, was, well, I'm here now. And I'm going to make sure that he stays in line, that he does what he's supposed to do. And I said to Cameron, that's great. And I hope dad does that. And I believe that he will. And I also said to Cameron, you're the only one who can control your own behavior. No matter what dad does, if you want to mess up, you will find a way to mess up. Yeah. So I do think that things have changed and will continue to change in his home life. And I think that, had this case come before you in 2023, when he picked up that juvenile case, and we had been able at that time to restructure things for him and to provide some services, right? So what happened in 2023 is the agreement and the probation included these programs through the juvenile court that would have provided him with a little bit more structure and some services. And that never happened because those programs went out of existence. And so it's clear to me that he needed some more structure and some more services in his life in these past couple of years, which I think that both his dad and Ms. Singleton are now going to provide with the GED program throughout the Promise Center, with the counseling through Chris 180, the mentorship. I think I always want to get my clients, my young men clients involved with mentors. I think that can be really great for them. So I think that he will now have he will be wrapped in services and structure that will help him maintain and help him stay on track. And it would be amazing if when he turns 17, he could have completed his community service and completed his GED so that he has even less to maintain once he switches over to DCS to supervise his probation. So I'm asking the court today not to revoke him for any time, to maintain him on probation, and to change those conditions of probation as Ms. Singleton outlined.
In speaking with Mr. Wright's father, what did you learn that made you comfortable that dad's around for a while and not, hey, I'm back, and then this is more complicated than I thought. I'm going to return to wherever I was when I wasn't around. I know that that's technically a question for you to answer. I don't want to put you on the spot. I'll hear from Ms. Gordon, and then you can chime in as you see fit. I'm not trying to pry into family situation, but I want to have some understanding of why that support structure would be there, because it sounds like Mr. Wright, meaning Cameron, and mom is a bad combo. But if that's where he's going to be in 6 months, Ms. Singleton doesn't make miracles. She makes things that are realistic happen.
Yes. I think sometimes she does make miracles, Judge, but that's neither here nor there. I will be honest with you, Judge. I met Cameron and his father in person today for the first time, and I spoke with them for the first time yesterday. This was not my case on the front end, as you know, and It just came to me. What I can say to the court is that in speaking with them, I can tell that Mr. Wright is invested in his kids. He has shown that by being here in court with him
Mhm.
last week and this week on time, I think even early. And I'm happy to let Mr. Wright speak if there is something that you'd like to see the court about that.
I couldn't do it. That's why he got in the trouble that he was in. But I'm here now. I just did 5 years in prison, so I ain't gotta worry about it no more.
Are you working now?
Yes, I am.
What are you doing?
Me and my dad got a business together.
What does it do?
I put up the garage door.
All right. How many hours a day is that typically for you?
It's still a contract, so we just go on whenever.
Okay.
They don't take that long to put them up, so probably like 6 hours out of the day.
Okay, but it's a steady enough work that it's keeping you busy and more importantly, keeping money coming in for you and your boys. Okay, and the house in Riverdale where you stay, it's you and your 2 sons, anyone else? Okay, so grandma for him, it's the 4 of you? And so your dad doesn't live with your mom? You said you're working with your dad. No, I'm asking you. You said you're staying, I'm still talking with you. You stay with your mother, but you work with your dad. Does your dad live with your mom? Okay, that's what I was getting. So there's another household where your dad is. You're in your mom's household. Okay, got it. Well, I'm glad you're back. Stick around. All right, thank you for being here. Thank you, Ms. Gordon. Ms. Dilligard, your thoughts about what to do in Mr. Wright, Cameron Wright situation?
Judge, ultimately, we're going to leave it in the court's discretion. However, when the petition was filed, and after speaking with the previous prosecutor on the case, the intent was to revoke the balance because this defendant here, Mr. Wright, had been given the benefit of leniency when he resolved his armed robbery down to robbery and took the benefit of first offender. And so to have been in possession of a handgun not even a year after that this disposition was sentenced is a concern for the state. In addition to all of the other posts of concerns with not going to school, not having completed any of the community service, fighting, and not having a stable living situation. And I don't know if I'm any more confident of his living situation since it's still kind of a fresh situation. So it's the state's intent to ask this court to order a custodial revocation in this matter, based off of everything that Your Honor has heard, but it will ultimately be in the court's discretion.
Okay, I appreciate that. And I certainly get the perspective that had this been something we dealt with in September of 23, so on the heels of the petition being filed, which was only a couple months after Mr. Wright had been arrested for what? Having a gun again at, I don't know how old he was back then, 15? I mean, it had to have been real clear that Mr. Wright and guns weren't supposed to mix. That part I am confident of. But now we have this passage of time, and during that window, as far as we know, no more criminal activity like this. Not a perfect life, but no one leads a perfect life. It is, I guess it was a chance for Mr. Wright to demonstrate, maybe I've learned a lesson, part of a lesson, since the June arrest, and a judge in juvenile court heard all about the facts and circumstances of that case and meted out the punishment that judge felt was appropriate. And so I think coming 2 years later to say, and you're in even more trouble for that, isn't the right fit at this juncture. But Cameron Wright, you need to know that we'll be seeing each other a few times between now and your 17th birthday. And each of those times you come here, I'm going to be asking Ms. Singleton how things are going. And if the reports are not so well, then I do need to think about something that shakes you a little bit to say, it's time to step up for your little brother, for your dad, for you. And one of those tools that I have is to say, I'm going to revoke a little bit of your probation. And at your age, that means you go back to a YDC, not a fun space to be. But I need to take the steps that I can take to get you as on track as possible. Your dad and the people closer to you have much more influence on you, and I know they are working to give you opportunities, but I'm going to be focused on that as well if you aren't taking advantage of what a place like the At Promise Center offers up. Okay? Do you have any questions about anything we discussed? All right. Well, what I'm going to do as a result of this petition filed in August of 2023, premised on conduct from June of 2023, for which you have already been adjudicated, if you will, in juvenile court. And that, I know it was a dismissal, but it was still something that a judge had to deal with, and there were consequences. I am going to modify your probation by modifying your sentence in this case. One thing I'm going to do is delete the residency requirement, so you are not required to live exclusively at that address in Riverdale, because it sounds like every once in a while it may be necessary for you to stay with a different relative. But home base hopefully will remain there. It sounds like the safest and most stable place for you. You no longer have to graduate from high school. Instead, you need to get your GED. And in particular, I'm going to require that you begin attending GED courses at the At Promise Center, and that you participate in the CRIS 180 treatment at the At Promise Center until CRIS 180 says you don't need treatment anymore. So you're going to have 2 reasons to be at the At Promise Center pretty regularly. They offer other things, like you heard, summer camp, that kind of stuff, which you may want to do. That's just not a condition of probation. You'll also need to complete your 120 hours of community service. And I expect the community service to be completed, and this will be a condition that you complete. What is the day of your birthday?
December 25th.
Christmas, a Christmas baby. All right. Well, that's an august group. So you will need to complete your community service by your 17th birthday. Ms. Singleton, where do you think Mr. Wright falls in the timing of getting the GED? Because I'd love to say, and you shall also get your GED by your birthday, but if he still has math and history and science to do, I don't mean to create an impossible climb, or they couldn't do it if he couldn't do it if he wanted, because the classes don't happen fast enough.
Based on the academic records that I had, I believe that he can finish it by December.
Done. So it will also be a condition of your probation that you complete your GED at the At Promise Center by your 17th birthday. Now that's one I'm willing to budge a little bit if it turns out that you do your best and you don't pass the history test, or one of the teachers is unavailable and you can't fit it in by then. I know you can do the community service. I think that's it in terms of addressing the amendments, the modification of probation. Did you have anything else I missed, Ms. Singleton?
If the court could remind Cameron that he's not to possess any weapons. While I have not seen any weapons, and that this was a constant conversation.
Sure. So I'll be very clear about that. It's a crime in Georgia for someone your age to have a gun. You're also a first offender probationer. It's a crime in Georgia for a first offender probationer to have a gun. Even when you turn 17 or 18, if you're still on probation, it's a crime for you to have a gun. That particular crime, if I get evidence that you committed it, is the kind of thing where I would be inclined to revoke a big chunk of your probation. You and guns have mixed in a real dangerous way already in your life. And so you need to not have them in your life. That means dad can't have one at home, because if that's your household, you're around it if you're living in a house where there's a firearm. So there you go. I forgot about that. Dad's going to be a very good role model there. It's a crime for your dad to have a firearm. So be like dad in that way. No firearms. Very little good will come to you being around them. And guys who want to say, hey, man, hang out with me because I've got a firearm, they don't have your best interests in mind. So just keep that in mind. And I will work with Ms. Nelson to set a date, unless we want to do it now, for when we're coming back to get it. I guess we could just work with you, Ms. Singleton, but I'm thinking it's May, probably 2 check-ins before his birthday, but one could be pretty close to his birthday. I don't want to wait till December 1, because if he has 100 hours remaining of community service, that's going to make for a mess of a December. So what would help you in keeping Mr. Wright motivated? I don't want Dad to have to drive all over Kingdom Come either.
Sorry for that.
No,
But I would like to check in 2 weeks to see if he's enrolled in the GED program. Orientation's on Monday.
Boom. Okay. Well, why don't I also make that plain, is that he is to enroll in the GED program within 2 weeks. Okay. You're a big kid now. You got to take some of these steps. How about I'll work with Ms. Nelson, and by the end of May, we're all getting back together again. Okay?
Thank you.
And then based on how that goes, we might say, all right, we'll see it in 2 months. So we'll do it bit by bit. If our meeting at the end of May is a sad meeting, then we might meet again in just a short time after that. And if that doesn't go well, it might be we're taking a timeout.
Yes, Your Honor. Thank you.
Okay. And in terms of representation, will Ms. Wood or Ms. Rios be? You'll keep it? Okay, so we'll be letting you know when that calendar goes out. We'll let you know as well. Okay. Your name is on the calendar. Did you do an entry? I don't know how your name got on the calendar. I mean, I know who put it there, but
I did not. I'm happy to file an entry if you need me to.
I just don't want notice going to Eric Johnson, because he doesn't need to be here, or he would be here, but you need to. So we just want to make sure you know of those calendars when we publish them.
I'll be here, Judge.
Okay. Ms. Dilligard, anything else from the state?
I have one question. I know we delete the resident completed, we delete the juvenile leave program.
Yeah, I didn't say that, but yes, that needs to happen. And it's being replaced by what I put in here on my handwritten notes is that LEADS or Juvenile Initiative is replaced with At Promise Center, which is sort of the overarching for the Chris 180 and the GED program. All right.
Thanks, Judge.
You bet. Thanks for being here.
Thank you.
All right. And thank you to both the Wrights for being here. Who? Rachel. Oh, I'm sorry. Is that the only one you're missing? Okay.
Yes, she should be. Correct.
Where's Cabrera?
She was texting me, Your Honor, and I just texted her.
I know, but she said 1:30, then it was 1:45.
She did text me, and I told her that I would text her when she.
I go to that and then come back. It'll only be 30 minutes. I don't know when Ms. Rivera's gonna get here.
Is she not on the call? We don't see her?
She's not on the call. You should go. You've been waiting for a long time. Your matter is a motion to reduce the bond for Amori Williams. Do you want to deputize Ms. Dilligard to handle that, or?
You can text me and I'll sign on.
Oh, you just hop on virtually?
Yes.
That's fine.
The victims, Mr. Coffey, his family, his mom, and his father are both present in court. And I can go ahead and state to the court now that they vehemently
Oppose any
reduction in bond.
Got it.
They didn't want bond to begin with, which is rightfully so.
Understood. Okay. And it's Mr. Coffey?
Mr. and Mrs. Coffey, yeah.
Got it. As in the beverage, that's how it's spelled?
Coffy.
Got it. Thank you.
Let me go see if I can get this.
Okay.
Now, I can wait 5 or 10 more minutes, it's about 2:30, right now, when she gets here.
Okay. Oh, as in their headquarters building. The trial that Judge Emerson just finished up was a murder, and the best surveillance footage came from APD headquarters surveillance camera. This dude shoots someone in front of police headquarters. Unsurprisingly, 100 officers responded. unlike Judge McAfee's courtroom.
I asked her if she could log on now, she's not responding, so.
Okay.
she can log on.
We're working on it. Are you able to join the 3:30 or does the APD thing interfere with it?
No, I'll be back.
Okay.
It's from 2:30 to 3 o'clock, pretty quick. So I won't be back.
It's not for you.
Okay, I was just gonna say, I just need the calendar.
Nope.
Okay.
It is not on the record.
Okay.
Are you all here for Mr. Mender or Mr. Williams or both? The front group is for Mr. Williams and then in the back for Mender? Okay.
So, and you're just standing and knowing what I know, so we left. And you see when he goes up the strap, he's coming back. That's the part that's weird. I wasn't certain when he's coming back, but it's weird. Crazy angles, he didn't know the building, he had gone in this over there. Yeah. I can't tell the part. So, we watched. Mr. Sound back there. Yes, I'm sorry, wait a minute. Oh, my. The street, everything's made that. I would have that one exchange of stuff. Okay, so when I look at it, you see the guy walk to the door first? Yeah. No one is about to get pumped in their car. My understanding from all this book that was. Yeah. To me, I don't know what the difference is. Because it's out, because it's a street. And I'm usually on the street, that's all. If he saw something, he would go to the street. I don't know if was having something. So I know the same thing. Quickly come back down. I don't know if it's an issue. That's what somebody always said when we were. I don't think it's guns, but I do. I really want for you. Just looking at it because I've never seen. It's myself. Right. Well, I think somebody he can't ready up. I don't
Right. Right. You know, shoot.
And so I just. But there's so much to get.
I'm sure it's a little bit above.
And nobody's seems to have that many information on that guy.
Right, and I'm sure they're gonna talk to you, but never get done.
Yeah.
What's that? What was that? So.
You said.
She had, I didn't know how big she doesn't.
She got, no, she doesn't. Okay, vision tells me, I'll call that night. Change this.
Yeah. All right, good. I will be back at 3:30 and then I'll sign on these.
Okay, so we'll just text you.
Still the architect.
Okay,
Yes.
someone, the group we, okay.
Okay. The, we can see the reduction.
Right.
But I'm gonna go ahead and just. Okay. Because we're gonna go group of kids down there and come back.
Okay.
Now Ms. Cabrera is signed on. Look at that.
Well, okay, wait.
No, I mean, he's got to be over at APD. We just do Mender until he gets there and then he can sign on over there.
Hey, Judge, I'm sorry.
That's all right. We're gonna next time take you on the road or something. But what remains is Mr. Williams and Mr. Mender.
Yes, I think, is Miss Hudson there? Miss Singleton?
Miss Singleton is there and now Mr. Abate's coming back. So we're gonna do Williams first because he needs to get over to APD headquarters.
Mr. Williams says?
Mr. Abate needs to get over to APD headquarters. Mr. Williams, have anywhere to go right now. And is he here? Can we bring Mr. Williams out, please?
Well, I'm gonna run to Judge Krause, so I'll be right back.
Okay.
Just announcements.
Okay, I've heard that before. William, should be the only Williams back there. Hey, Mr. Williams, let me get your camera on as well so you can see your lawyer and she can see you. And then Mr. Abate, if you either move to the middle chair or move that camera, that way everyone who's in the mix can see everyone. All right, great. Let's go on the record. This is 24 SC 006-518, State versus Amari Williams. Mr. Williams is in court. His lawyer, Ms. Cabrera, has been moving furiously from courthouse to courthouse in Metro Atlanta and has landed safely somewhere. She is appearing virtually, but we can see her and hear her. And Mr. Williams, your lawyer, Ms. Cabrera, filed a motion for bond reduction a couple weeks ago. and that's what we are here to discuss. I set a bond in your case a while ago, and to be clear, your case is one in which you're charged with murder, felony murder, armed robbery, aggravated assault, etc. It resulted in the death of someone. So serious charges. And I set a bond, and Ms. Cabrera, her motion indicated that the bond that was set is beyond your reach, your family's reach. So we're going to talk a little bit about whether I ought to reduce that amount or if that remains a reasonable amount given all the things I'm supposed to consider. Okay? Ms. Cabrera, tell me what you've learned since we were last together in March.
Okay. So yeah, Judge, he has a $150,000 bond. The quirky situation with the bond is that it's also under supervision through pretrial, which apparently eliminates his family's ability to go through a bonding company in order to make the bond. So this is something that has to, I guess, be done directly through the jail, and then he'll get pretrial supervision or what have you. When we had the hearing on March 17th, I think it was the 17th, around the 17th, 13th, I'm sorry, March 13th, one of the last things that Your Honor said as he gave him the bond amount for his release was that if this was something that could not be made, that we needed to circle back within 30 days and let the court know, and the court would consider whether or not it would do anything different. I know we have reached out in between just to kind of get clarification and understanding about the difference between being released on pretrial supervision and the ability to actually go through a bonding company. But the family's at a standstill on their ability to be able to make his bond. I think his mother should be in court today. He may have other family with him in court. I know he had quite a bit of family with him when he was in court for the bond hearing in the first place. But I do know his mother is definitely present, so she can explain that to you if Your Honor wanted to hear from her. There's other concerns that we have about his currently being in custody. And so, you know, there's been some, he's had I think a fight or two since he's been in custody, nothing of his doing. He was jumped on. There's also been attempts at extortion and all sorts of things. They have kicked him off of phones. They have everything since he's been there. And so it has been not unusually safe, but it is a safe situation. It's an unsafe situation for him. Unfortunately, this is something that does happen when they are in custody. But this is a young man who has not been in custody before. And he's doing his best to stay out of harm's way, but it doesn't mean it's not following him. So I would ask for Your Honor to consider a reduction in this bond so that they can make this bond, have it be under pretrial supervision as the court intended, or perhaps put them in a position to use a bonding company. I don't know what Your Honor's preference would be, but I'm definitely asking that Your Honor consider tweaking this bond to give his family an opportunity to actually get him out.
Okay, thank you for sharing that. Mr. Abate.
Thank you, Judge. The state would respectfully oppose a reduction in bond as requested by defense counsel. The bond that Your Honor gave back in March, the state would, I guess, feels that it was more than appropriate and more than fair. The family members of the victim, Mr. Coffey, are present, both his mother and father, both who were not supportive of a bond to begin with and are strongly opposed to any reduction in bond. What I would submit to the court is that the defendant, during his statement to the detective with the Atlanta Police Department, admitted that this was a planned armed robbery, that he was the person who reached out to Mr. Coffey and set it up and then was present. And then based on the ballistics evidence, there is...
Is this a gun transaction?
Yes, Your Honor. Mr. Coffey came from Douglas County and drove to the incident location that was provided by Mr. Williams. And as Mr. Williams admitted that the plan was to rob Mr. Coffey of money and guns or whatever he had on his person. Instead, he was shot in the head, and the person he was with, Mr. Arnold, was shot in the stomach, but miraculously survived and was able to identify all parties. So there is evidence that everyone who was present fired a gun based on the ballistics evidence preliminarily. Confirmation of that is subject to the GBI testing, which all ballistics evidence was sent there. So we're still waiting on that confirmation. But based on the facts and the evidence and based on the strong opposition of the family, the state would respectfully request that you deny defense counsel's motion. Mr. or Mrs. Coffey may want to make a statement. And I'm gonna let Ms. Gilligard stand in for that.
Sure.
And I'll be back at 3:30.
Okay, I appreciate your making yourself available like that. Mr. Coffey, if you come just right to the table there by Ms. Dilligard. And I appreciate you being here. I know this is a difficult topic.
Yes,
and it involves the most extreme loss a father can have. But why don't you share with me what you want to share about this situation, understanding that I respect your disagreement with the decision I made earlier, but we're not here to say, should there be no bond? It's, should there be a modification to the bond that I concluded was reasonable under the circumstances. And I don't know that you had an opportunity to be at the first bond hearing. You may not have been given notice, or you may have had other things going on. I think this is the first time you and I are meeting.
yes, sir.
Okay.
I understand it all.
Can you lean into the microphone a little bit so the court reporter can hear you? Thank you.
Yes, sir, I understand the law. It's a lot of ways that the law had to operate to do things. But we talking about the death of a young man.
How old was your son when he died?
He was 20 years old. I have two other kids that are 30, 25, and I did all I could to raise my kids the right way. My kids ain't never harmed nobody. They all work. They did what they supposed to did. My loving, beautiful wife right here. It's just hard on my wife. The respect is that, we thought they supposed to been friends. And somehow things turned the wrong way. Me and my wife still consider that if the other two gonna be punished, he should be punished too. It just fair. That's how we feel. It's just fair.
I understand that.
We got some the other young man that is the best friend of my son. He don't stay too far from us. He ready to come to court and testify against certain things.
This is the gentleman who got shot in the stomach.
It's one that got shot 3 times. He stayed about a good 10 or 15 minutes away from us.
Got it.
And he ready to come to court and testify and point fingers at whoever he need to point fingers at, that he know that was there at the scene. Now I got another something that y'all don't know nothing about. My nephew, Kemonte Hamilton, that is from Hollywood Court. He's a part of doing something with the gun first. Him and his friends spoke and took a gun. This is for my son's death. This is what my son is telling me, that my nephew took a gun from someone, and however they involved my son. So if you don't mind, Your Honor, I would like to have him subpoenaed to court too, for he can give y'all some more inlight of what really went down and what really happened about that gun.
Okay, so I hear you on that. You're going to want to share that with Mr. Abate, the gentleman who just had to leave, because that's more an angle that he would explore. So certainly keep that information and share it with him so he can figure out where that might take the investigation. Okay?
Yes, sir. Yes, sir.
All right. Anything else you want to share?
No, sir.
I appreciate.
My wife will just so.
Okay.
Pretty much like you should have.
Come around, man.
Pretty much feel like you should have had a warrant
Because my baby can't come home, so I feel like he shouldn't never come home to his family.
Okay. I understand that. I hear that, sadly, often when we have a situation like this, you don't get to hold your son again. And so I understand that perspective. I know this continues to be a difficult time for you all. My focus is getting this case to trial as soon as possible so that whatever closure ends up meaning, can happen for your household as well as the 3 households of the people who've been charged with this. And we'll let the jury decide what happened. And once they speak, then I'll take it from there. But you will be notified of all the upcoming court dates for each of the defendants. And you're entitled to be here for each of those. And certainly, if there's a trial and there's a guilty verdict as to one or more of the defendants, it'll be another opportunity for us to have a conversation about how this has impacted you. I understand how it's impacted you and what you think the consequences ought to be. Now, today, of course, we've got 3 people who are presumed innocent. They're charged and you have your own view of what they did, but you know how the law works, like you said, Mr. Coffey. And until the jury says guilty, I treat each of the accused as someone with a whole group of rights and attorneys fighting for those rights and the presumption of innocence in their favor. And so I'm going to handle it accordingly. We've got a trial date in early August, and I hope we can keep that trial date. It's tricky with 3 defendants because you got to line up a bunch of schedules, but we'll certainly keep you guys posted on all that, okay? All right, I appreciate you both being here.
Thank you.
Ms. Cabrera, anything you want to add? You're on mute right now.
I'm sorry, Judge. I don't personally have anything further. Would you be able to ask if his mother has anything that she wants to add before you make your decision?
I'll ask. There are about 20 people here for Mr. Williams. I don't know that I
Just
need to
looking
hear
for his mom.
all of them. I don't know which one is mom in the bright red. Hey there. Is there anything that you want to say? And if so, if you come around just to the corner there so it's easier for the court reporter to hear you. That's good for me.
Sure. First of all, I want to say I'm sorry for your loss. I really am.
I need you to talk. You can say those words, but it gets complicated in court when people are looking in different ways. So you and I'll have the conversation, but you should communicate whatever you want to communicate.
Okay. Well, I am sorry for the other parties, but both of us are looking for, what is it? Justice for both ends. I understand they look for justice for their son, but I'm looking for justice for mine as well, because at the end of the day, he didn't know this was gonna happen. And I know you gotta go try and you gotta figure out the facts. So I'm not here to do all that. I just want to tell them I'm sorry for their loss, but Martin didn't have a hand in what happened. He can't control the people around him, and Martin doesn't come from that.
This is your opportunity, Miss Williams. Make sure you're letting the court know your thoughts on him being released. Because judge can't decide anything that you're telling him about now. He can only focus on the issue of bond itself.
Right. Well, yeah, it's very imperative that we get him out of there. It's the only safest place for him is that we get him out of there. I mean, at the end of the day, whether he's home, if he's home, at least we know he's safe at home. He's not getting beat on. He's not getting jumped, because he's trying to cooperate and he's doing the right thing. And because of that, harm is coming his way. And the safest thing for him is that I know he's at my mother's house and he's home, and
And that's where he'd be staying, is at your mother's house?
Right. We just want to get him out of the environment that he's in and put him in a safer environment so that we can know that he's okay.
Got it. And that's what we have here. It's stay with Evander Jones. I guess that's your mom. There she is. Hey, Ms. Jones. Okay. Well, that's the plan if you can make the bond. Okay. And in the same way, I understand what you're feeling right now, because your son is not in a happy, productive environment where he is right now. Okay. All right. I appreciate all of you being here. All right. So, Mr. Williams, what I'm going to do is confer with pretrial services. I'm not going to lower the bond amount. I think that bond amount is reasonable, given what I've heard about the charges and your situation. But I'm kind of neutral on whether it's through the 10% program or through a bonding company. And I think it's more affordable for your family if it's through a bonding company. The important part of the bond to me was the pretrial supervision. And I have been talking with our pretrial supervision office, not about your case specifically, but whether they'd be willing to do supervision, or they're authorized to do supervision when it's through a private bonding company. So I need to have a conversation with them to see if maybe it's a split bond. So again, it's the same dollar amount, but maybe some of the bond is through a bonding company, and then the rest is through the 10% program. But I will engage with them on that. And if they tell me that they can do their supervision, but a significant portion of the bond can be met through a bonding company, then I still have the same comfort that your family has put a lot of money in, saying you're not going to disappear. And we still get the good supervision of pretrial. Because the difference between a bonding company and pretrial is pretrial lets me know right away he's not complying. They bring me a warrant, I can sign it, and then you're right back where you were. Bonding company just tries to find you if you don't show up for court. But that's less helpful because it's too late by then. So that's where we are. I will talk with the folks at the bonding company, at pretrial, and we'll take it from there. Any questions about that?
Am I gonna have to come back to court?
Are you gonna be able to come back to court?
I'm gonna have to come back.
No. This is all stuff. I'll talk with pretrial, and if they say yes, I'll modify it. What I'm trying to make clear on the record is the dollar amount will be the same. It's still pretrial supervision, all the same conditions where you've got an ankle monitor, this curfew, everything is in the bond, and your family has it. And if they don't, your lawyer can get it to them. That won't change. It will just be the way in which the bond can be paid out is different. And I don't do lots in that space, but I'm hearing that $100 bond through the 10% program actually costs a little bit more than a $100 bond through a bonding company. The big difference is the money that you pay in through the 10% program, most of it you get back. And so I was trying to make sure your family, they're investing a lot to post this bond, that they could get some of that money back once your case is resolved, whether you're acquitted, you're found guilty, you work the case out. Once your case is closed, that money goes back to your family. Not so with a bonding company. Bonding company is in it to make money. And so whatever your family pays, that goes into the bonding company's pocket. But that's their line of work. Did that answer your question?
Yes.
Okay. One last thing, and this is more addressing something your mom said in terms of Mr. Williams trying to sort things out. That's the sooner Ms. Cabrera can connect with Mr. Abate about working things out, the sooner something like that could happen. It doesn't have much to do with where he's in custody or not. So hopefully those two lawyers can connect soon to see if there is a way that Mr. Williams can make his situation better for himself. Okay. All right. Thank you, Ms. Cabrera, for dialing in. And Ms. DeLagarde,
I have one more. I can't go anywhere.
No. I didn't say you're done. We're wrapping up on Mr. Williams.
All right.
You'll let Mr. Abate know what happened?
Yes, Judge.
Okay. All right, Mr. Williams. I will see you at the latest, regardless of what happens with bond. You've got your final plea date in about a month. That's when I would see you. That's the last day you could enter a plea and withdraw your plea if the sentence I gave you was more than what you and Ms. Cabrera asked for. So stuff will start happening soon, because if there is going to be a negotiated resolution where maybe the state's going to dismiss some charges or reduce charges, that happens before then. And once that happens, we'll get you in front of me. Okay. All right.
Thank you, Judge. So I'll check back with you and Ms. Nelson about
I have to talk with, yes, ma'am. I have to talk with pretrial anyway on a couple other things, and this is one I'll explore with them.
Okay.
So what we've got next is Mr. Mender.
Yes.
If we could bring him out.
And Mr. Mender.
Oh, let me ask, Mr. Coffey, you understand what we did today? I'm not changing the bond amount. It just would, I might change the way the bond could be structured through a bonding company versus through the sheriff's. It's all the same conditions. If he does post that bond, curfew, gotta be at grandma's house, et cetera, and clearly staying away from you all. Don't break our key.
We'll let Mr. Biden know.
And it looks like Mr. Mender is also on for the 8th.
Yeah, you gonna be here in person?
Yeah, I am. It looks like he got sped up by his co-defendants because his original final plea date wasn't until June 17th.
Oh, yes, because of the speedies that were filed.
Correct.
Right.
So,
Okay.
I have to circle back with the state. I don't have a recommendation on him or anything like that, as it relates to the
Okay.
new court date.
Got it. Well, and he's not losing any final plea rights. We just, once the speedy was trialed, we started putting this on trial calendars. So, but hopefully you and Ms. Dilligard can talk soon.
Okay.
Excuse me. Let's get on the record with our final position of the day. It is State versus Quinard Mender, 25 SC 000-816. Mr. Mender is in court. Mr. Mender, your lawyer, Ms. Cabrera, is on the screen. You see her in front of you? I'm going to make you a little more visible since you are seated there so she can see you. There you are. And we'll take that screen off. Okay. And Mr. Mender, Ms. Cabrera filed, I'm going to stand up so you can see me. She filed a motion to modify your bond. I set a bond in your case. And apparently the dollar amount is higher than your family can make. And we never know, right, when we set a bond, is there this much money or that much money? So I'm going to hear from Ms. Cabrera a little bit about bond. And I'm going to hear from Ms. Dilligard, who's seated over there with the Mountain Dew. And she's the prosecutor. She's going to let me know what she thinks. And then I'll tell you what's going to happen. One other thing about your case, you have two co-defendants and their lawyers have filed a motion that's made things move a lot faster. So you're actually going to be here again on Thursday because we need to figure out if people are ready to go to trial. Those lawyers have said, because I did not set a bond for those defendants, that they want to have a trial to figure out what's going to happen with the case. So right now you're moving along with them. So you'll be back here on Thursday, not to start the trial, but just to talk about when we can do that trial. Okay. All right. Ms. Cabrera.
Yes, I don't know. We may actually want to hear from Ms. Singleton first. You've actually laid out exactly why it is that I've presented this to the court. He really doesn't have any what would otherwise be a change in circumstance that would bring this back before the court for a reduction. This is just something that we kind of knew in the beginning that his family may not be able to afford, but his mother has tried and she just cannot.
Okay.
And like Mr. Williams, at the conclusion of that bond hearing, you alerted us that, you know, if this was something that could not be done within 30 days to let the court know and to bring it back for you to reconsider it.
Okay. So it effectively is functioning as no bond because the family can't make it.
Correct.
Okay. Got it. Ms. Singleton, I don't know if you've got things to add. I guess you can tell me how Mr. Mender is doing at the YDC, but you wouldn't have been working with him, or do you work with him at this point?
I just see him at the West.
Okay.
There's been no reports of him being involved in anything at the YDC, which the court is aware of. There's a lot of things going on at the YDC, at the ROI. But I received no negative reports about Quinard, as the court may recall, he did have no history and was an eighth grader, last at the time of arrest.
How old are you, Mr. Mender? 18?
15.
15, okay,
His birthday's in December.
okay. All right. Ms. Dilligard.
Judge, we'll leave the reduction in your honor's discretion. This defendant, although wasn't one of the ringleaders at the incident, he was involved in a senseless act of violence that we are taking into account. However, we understand that the family is not able to post the bond. I do believe that the bond was appropriate in this matter, and we'll leave the reduction in the court's discretion.
Okay. Ms. Cabrera, have you and Mr. Mender's mother talked about what is an achievable amount? I don't want us to have to do this once a month because it's still out of reach, but I also don't want to say, hey, $10 bond.
Right. And I honestly think, so for her to come up with even $1,000 to make this bond is going to be tough. She's not working. So it's going to be tough, but I don't know if she's allowed to maybe also do hers through a bonding company. This is through the 10% program, which we're learning is puts them in a different posture as far as what has to be paid out. Maybe allowing her to do it through a bonding company may give her a little extra space to try to pull together some money. But I know with her not working, there's other children, she just doesn't have it. She's in a really tough spot. So if Your Honor can make it lower and allow her to perhaps go through a bonding company, maybe that would help. And I'd like to speak to, between now and Thursday, I'll speak to Ms. Dilligard because there was some request of Ms. Dilligard that I think we can make. We can do. We just have to kind of talk to each other and that way I can speak to Mr. Mender and we all be on the same page. But I think some of her requests we actually can make good on.
Okay. Well, Thursday is 2 days from now, so hopefully you don't have a schedule like you do today, Ms. Cabrera, but you guys hopefully can connect. Ma'am, are you Ms. Mender, different last name? Ms. Galinga. When did you last work?
I haven't worked since January of last year. I do live, but that's up and down depending on the day or whatever. Like this day, Friday was all that day.
Sure.
It's just varies, throughout the day or whatever. So that's mainly right now what I'm doing. I do have a job interview set up for a reception next week. I went in and found out he had work on Thursday, so I went in and rescheduled it for next week. So I am actively looking for employment. I've been a store manager for about 10 years. And so I'm trying to get out of that field because I was working one night and one of my sons was hit and killed in hit and run. So it took me a minute to get back to work. And so when I got back in that position and I found myself going back to the same thing, being at the store long hours and of course my kids are getting into different things. I had to step back from that again. And so
sure.
That's what I'm really doing. I'm just basically just trying to find something that fits me and trying to get him back out and him on the right path or whatever.
How many kids do you have?
Right now I have 6. I had 7. I have 5 boys. With Mr. Mender father, when we lost one of our sons, it's like 2 daughters. They're 26 and 24. So, but now it's my youngest.
Okay. And do any of the adult kids live in your household and contribute to the household?
No, they all have their own because they're also our mothers. So my daughter, that's 26, she has an 11-year-old, and my 24, she has a 1-year-old, and then 4-year-old. So they live with their baby fathers or whatever. So it's just me right now, and Bernard's in custody once passed. So just my 3 sons, one is in high school, and the other 2 are 18 and 20.
Okay. All right. So you left the store management role. You're doing some lift, but then you are exploring maybe being a receptionist.
I want to do something that it works some schedules. Working on that, doing those nights.
Right. Okay. And your place is the apartment on North Side? Okay, all right, thank you. Ms. Singleton, if the bond is not through the sheriff's 10% program, do you still provide all the services, or you can't? Or how does that work with someone Mr. Mender's age?
The bond orders that I have, there's a line that says supervision, it's something to the effect of supervision by pretrial, and it's either does have or does not have.
Yeah.
And the judge has been checking does have.
Okay.
On the screens.
Regardless of whether it was a private bonding company or through sheriff's 10%?
Well, on the 10%, they just picked 10%, but on the private bonding companies, they've been checking supervision by pretrial.
Okay. So you do have, or you have in the past, supervised juveniles who got out on a corporate surety bond?
Yes.
Okay, that doesn't keep them from you?
It has not.
It has not so far. Okay. Then I need to have the same conversation. Pretrial and I have been working through a new bond form that deals with ankle monitors. So they're I won't go into all the details, but I've been working with them about a new standard bond form. And there's been some confusion about judges saying private bond, but pretrial, and how they're going to process that. And you occupy a slightly different space in there. It's still pretrial, but I wouldn't want to issue a bond and not have you plugged in a situation like this. But it sounds like I could do that and have it go through a bonding company, which just makes it a little more affordable to Mr. Mender's mom.
Yes, Your Honor. And then he would get the wraparound services, the ankle monitor by the GHA.
All the stuff. I'm not doing, I mean, the bond, all I do is modify the bond to change the dollar amount and say it can be cash or other good bond, except what it says right there is no pretrial supervision, and that's not accurate. So I have to fix that. That's where I'm working through with pretrial. Okay. Mr. Mender, we talked a lot. That last little bit isn't directly your situation. Do you have any questions about anything we discussed? Okay. I'm going to see you on Thursday. You'll be brought over here again, and it may be that I just bring you out to say we're still working on your case, but I'll make sure that I check in with you on Thursday, okay? All right. I will talk with pretrial services and figure out how I can restructure this. I'll probably lower the dollar amount some. What I'll definitely do is take it out of the 10% program, because that will make it more affordable to Mr. Mender's family. And importantly, Ms. Dilligard, if you and Ms. Cabrera can connect, what would be great is if on Thursday, and I appreciate that's super soon, we're talking about something other than bond in connection with what's happening with Mr. Mender's case.
Yes, Judge.
Okay. All right. Thanks.
Thank you, Madam.
I think that's,
I will see you on Thursday.
yep. See you then.
Okay,
And poor Miss Jackson, you were on this entire call. I don't think we had zero pleas, and I hope you're able to do something else, play solitaire or eat your lunch or something like that. I feel like I take up all your time, and we didn't get a benefit from any of your expertise.
No, that's okay. I'll see you tomorrow.
Yeah. Well, no. Well, I don't want to say no. Tomorrow, I guess we got the revocations in the afternoon. And I guess I am going to want to hear about criminal history, because one of them is just now going to be the straight revocation, not an evidentiary hearing. So, yes, I will see you tomorrow.
Okay. Thank you very much. Have a great day.
You too. Thanks, everyone. Bye-bye. Oh, am I not supposed to end the Zoom? Please leave Zoom up. Okay, I'll leave that up. We'll be back for the, I just ended the other part of it. So 3:30, long day for you. Sorry about that. At least you got your Mountain Dew.
Yeah.
All right, so I'll be back in a half hour. and we'll talk shop. We're gonna have some pleas off the trial calendar?
believe so.
Believe so. Okay. Mr. Leak. This Denson guy, are those your cases?
No, I do believe those are gonna be.
Oh, no, because he keeps beating up his girlfriend.
Yeah,
And that is Ms. Charles?
yes.
Okay, that's right. She was here, but then there wasn't a lawyer. His situation is,
And I wasn't sure for those bond revocations, if I was like, because at first I thought that was gonna be my case, and I wasn't sure I was supposed to have witnesses here.
no, if it's coming from me,
Okay.
then you don't have, hey there, we were just talking about you.
Catching me up.
Yeah, look at that.
Wow.
I say, Miss Charles, whoosh, she comes in like a genie. No, if you are petitioning to revoke a bond,
Okay.
then you need to have whatever evidence you think would prove it up.
Right.
If it's coming from me, it's because I figured out, wait a minute, you were on bond for something, and you got arrested for something else.
Yeah.
I can take judicial notice of their being booked in. And so like, there wasn't gonna be any pushback I wasn't wanting to get into the facts and circumstances of were you driving, whose rifle was in the backseat. If I wanted that level of detail, I would have let you know, hey, could you bring in a witness on that? To me, it's the fact of getting arrested. And for this Denson guy, he got arrested. He allegedly does something to his girlfriend, gets indicted while out on bond. Well, he hadn't been indicted yet, but while out on bond, he does something else to his girlfriend, allegedly. But I don't understand how he got the second bond.
Yeah.
And more importantly, why his other bond didn't get revoked. So that's on me, and his new lawyer, Scott Smith, can explain why he shouldn't, but it's not a witness thing for the state. It's an argument thing for the state. Ms. Clark was ready to revoke Leak's bond, and she had a good point, but we're right there on the verge of trial, and I didn't realize he didn't have ankle monitor anymore. We were able to tighten that up. This guy Denson also has a bunch of ankle monitor violations. Leak didn't have that, so we'll find a date.
Are you? I'm well, are you?
I guess you're gonna be out here for the 3:30, because I'll be out here. Oh yeah, take it. I'm going away. I'll come back out at 3:30, and it's low key. I'll lose this. All right, you can put on your tank top. That would be scary.
Anything? Do you have something on this?
I do, I think I know. So these dates that he's unavailable. So
For the 19th.
But he's unavailable end of the week. And I saw it, so
Wait, we don't know.
no, so we've been talking about this because it's very complex. Yes. Michelle or you, because you're coming up with you guys and you get to see a really complex murder and how we can. And so I said, Jazzy, I don't know that we can show us anything. Yeah, there's one blue we could do. So just I don't know if we're taking a bunch or at least bourbon. So if you're available, I'll be good. And then I know that Asian accent is sick, but there's the arsenal, that's the consolidated, yeah. And then but I think Jeff Hawkins is the first out of that, so careful how the arsenal if not.
Okay, Miss B.